Hello and welcome to the October, is that loud? October 21st, 2025 meeting of the Governmental Accounting Standards Board. Great to have everybody here, or almost everybody here, with us for our board meeting here at the TWA Hotel and at JFK. We just got finished with a wonderful GASAC meeting over the last day and a half. Got to have a lot of input and are looking forward to our board meeting. I guess it is worth noting and highlighting that I said almost all of us were here. Chris, unfortunately, had a conflict with an important conference that his organization sponsors or is hosting. He's really involved with, and the dates just didn't mesh up. So Chris isn't here, but he has given Alan his feedback and responses to the paper's inquiries. So Alan will be kind of providing those throughout the meeting here today and tomorrow. And we've got a full agenda going through a lot of our projects, hopefully getting through 3 items this afternoon. But first, we have to approve the minutes of our last meeting, which was September 29th of 25. Don't see any discussion on the minutes. Do I have a motion to approve them?
So moved.
Thanks, Diane. And a second?
Second.
Thanks, Jeff. All in favor, say aye.
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 Any opposed? Hearing none, minutes are approved. And we can go to our first topic, which is subsequent events, of which we have a pre-ballot draft of a final standard. Emily, I'll turn it over to you.
Thanks, Joel, and good afternoon, everyone. So yes, we do have a pre-ballot draft of a final statement to go through today. We are nearing the end of the road. It's very exciting. And then we also have 2 papers after the pre-ballot that we'll be talking about the cost-benefit considerations and the scope of authority. So we will start with the pre-ballot draft. We'll work from attachment A, which is the markup version. This shows changes that were made to the exposure draft that was issued. If you provided us editorial type of comments, we do have those, and we'll take those into consideration as we move into the ballot draft. If you'd like to discuss them today, feel free to bring them up, but otherwise we do have those, and we'll be looking at those as we move into the next draft, if that's how we pursue. The cover memo also highlighted an issue regarding terminology, and we also heard some feedback from GASAC members with regard to that topic. If we can get through the standard section and the basis and then talk about the terminology, I think that would be easiest. So we'll take the draft as we usually do, starting in the standard section.
And Emily, when you say terminology, like specifically the terms we're calling these, like recognized subsequent event, as opposed to recognized event. That's the terminology you're talking about.
Yes, thank you for that clarification. Yes, that specific terminology. We will start on page 1 of the draft, and we'll take it paragraph by paragraph or in sections. And so please feel free to provide your comments as we go through the paragraphs. We'll start with paragraph 1 on the introduction.
Any board comments on paragraph 1? I think we're good on that one.
Great. Starting off strong. We'll move into the scope and applicability section. So paragraphs 2 and 3. You'll note here that the specific scope provision that talks about the standards being applied in absence of other more specific provisions has been moved. That now resides down in paragraph 6. And that's because that scope provision is specific to the requirements for recognized and non-recognized events, which is now a little bit different since, as part of the redeliberations, the board tentatively decided to add the requirement to disclose the date through which subsequent events are evaluated, and that applies to everyone and in all circumstances. So we restructured that a little bit, and that's why you see that move. So any comments or feedback on paragraphs 2 or 3?
Any board comments on paragraphs 2 or 3? Don't see any comments there, Emily.
Okay, we'll move into the subsequent events general sections, paragraphs 4 and 5.
Comments on 4 or 5? So Emily, I was good with 5. And you just said, right, that the reason 5 is where 5 is because it applies to everybody. But I also kind of did highlight some GASAC comments about that not being clear. And I wondered if maybe we just add something to the front of the sentence, like whether or not there are any subsequent events, comma, the date through which subsequent events are evaluated should be disclosed in the notes. So not changing the sentence, but add that little phrase up in the beginning. I wonder if that would just, without too much fuss, improve the clarity. Robert,
I would concur with Joel's suggestion in that regard. I didn't think until we had the feedback yesterday. I didn't think of it in that term. I was probably more focused on a subsequent events footnote where you actually disclosed a non-recognized event versus in any instance, and you would have in the location to be determined, but probably somewhere in the summary of policies or somewhere. But I think that would be a good clarification.
thanks, Robert. Any concerns by any board members with adding something like that? Or from the team?
I think we're happy to look at some language
Okay.
to add. We can see what we'll do if there's no
Is
other
everybody
concerns.
good with trying to see if we can do something like that? I'm getting nods of heads, yes, from everybody. Okay, excellent. Anything else on paragraphs 4 or 5? I'll note there are some GASAC members here in the back. See, we do listen, right? That was specific GASAC feedback added. All right.
Okay, we'll move into the recognized and non-recognized events section. We'll just go ahead and take paragraph 6 by itself. And so this is the scope and applicability provision that has been moved from paragraph 2.
Any board comments on paragraph 6? So far, we're rolling.
Don't jinx us. We'll move into the recognized events sections, paragraphs 7 and 8. You'll note in 7 that we did revise the language a little bit. This is just somewhat the evolution of the project and continuing to think about the issues and the best way to describe what a recognized event is and what it does. And so we've modified, that's the modifications there. Some of those modifications came about through the board's discussions and tentative decisions earlier, and then a few more as part of the drafting of this draft. And then in paragraph 8, that final sentence that you're seeing as an addition was the direct result of some respondent feedback.
Thanks, Emily. Any board comments on paragraphs 7 or 8? Don't see any comments there.
Okay, we'll move on to,
Sorry, Jackie. Did I miss you?
No, you didn't.
Oh,
I
okay.
was late to it.
All right.
So I did make a comment, and this may be editorial more than anything else, regarding the way the footnote was worded and whether it was somewhat confusing in that when we talk about it, it says, or other long-term financing activities. And I was wondering whether that was somewhat confusing to readers because debt is another financing, long-term financing activity. So I'd recommended that maybe to clarify that, maybe something like, or non-debt related long-term financing activities. And I know this came up yesterday too, a little bit on what exactly did we mean by debt related transactions. So
You're in paragraph 9, right? Or are you in 7 or 8? Okay. I was just making sure I wasn't missing something. So we weren't jumping in late, you were jumping in early.
I was jumping in early. So I thought the footnote was related to 8. So
all right. So paragraph 9? Emily?
9 and 10, sure. Yep.
Did you want to talk about any of the changes or?
So the intro to paragraph 9, we had a discussion with the board a few meetings ago, actually as part of the notes discussion with the board, but we talked about clarifying that what was in that lead-in previously, where it said on the basic financial statements, was being interpreted as a direction on at what level to apply materiality. And that was not ever the intended focus of that. It was rather to say that the subsequent event must have an effect either in the financial statements or in the notes, so in the basic financial statements. So that's really what the lead-in change is resulting from, that discussion and that respondent feedback. And then the other changes, the removal of paragraph D was the result of the board's tentative decisions. And in paragraph 10, that addition to the new last sentence was a respondent suggestion.
Thanks, Emily. So Jackie, now your comments on footnote 1, which was added.
So I was just clarifying the language a little bit to make sure that when we're talking about what transactions were not in scope, that people were not confused about whether debt-related transactions were included or not included.
And was your concern the same as what we heard at GASAC, that it isn't it almost feels like they're specifically excluded, as opposed to what we meant was they're not part of debt related, but that doesn't mean they are out of scope. They could meet 9D, and that you had that same concern.
Right. This just addresses the debt. They could be addressed somewhere else.
Other board members have concerns over the footnote or share?
I have one other comment related to the footnote, not directly related to, I think, what Jackie's talking about, but as far as, I'm certainly supportive, right, of making clear that the footnote doesn't excuse the long-term financing activities from the entirety of paragraph 9. I understand how we intended to write it and how one should literally read it. That should be the case. But I don't know if there's a way we can put some words in there to further make the point that this does not excuse you from 9D. This only excuses you from 9A. I would be in support of that if we could do that. As far as, and I think we heard some of that in GASAC. I think we also heard another comment at GASAC, which was related to a comment I gave to staff, was this first part of the footnote: the term debt-related transactions does not include scheduled debt service payments. So my question to staff, which I think was what a commenter was telling us yesterday, do I mean regularly scheduled debt service? Because when I say regularly scheduled debt service, interest payment dates, mandatory redemptions, those sorts of things, I agree, those shouldn't warrant it. Non-regularly scheduled, like an optional redemption, something's going on. Now, an optional redemption scheduled, it's got a date. Every indenture tells you what date the redemption has to happen. So if we were to insert does not include regularly scheduled debt service payments, I think it would further clarify what I think ought to be in versus what, and I think this is consistent, I believe, with what the commenter at GASAC was talking about yesterday.
So Jeff, your concern isn't when somebody advance pays off or whatever, that even though you're not saying, yeah, at some point that it too is scheduled, you're talking about in the original indenture or whatever, there was this optional redemption point in time that is scheduled because it was in the original indenture, and you're worried about whether or not that would be included or excluded, or maybe we're more worried you would think it would be something we would want to know. And so you want to avoid it being mistakenly lumped in with this. And you think regularly scheduled somehow is better than.
That's the term of art we use.
Is it?
In my history as regularly scheduled debt service as opposed to an optional redemption, which is scheduled, but it certainly isn't regular. You may never have an optional redemption under your indenture, right? But it would be scheduled if you did, but there's something unusual going on. And I think that unusualness is the type of thing that you would want to know in a subsequent event. And so to try to capture that, I think that would be what I would propose to add.
So to me, there's two things going on. One is, do we ask the team to kind of craft the language here better to have these other financing things clearly what we intended them to be? And then two, this regularly scheduled or something like that. I personally, I'm fine trying to see if the team can craft this footnote a little differently to be clear about the other financings. I originally, from what the GASAG member was talking about, I wasn't really sold that we needed to do the scheduled, but the way you just described it, I'm becoming more swayed, and I wouldn't have known a term of art of regularly scheduled was somehow meaningful as a differentiator between these scheduled optional redemptions, but
yeah, I mean, because that's regularly scheduled is your interest payment dates, your mandatory redemptions. So that I think that would be well understood. I'm happy to have staff look into whether there would be a better way to communicate that, but.
All right, what do other board members think about those two? Jackie's already kind of commented on the first one, but.
I'm okay with the second one too, if it
Okay.
it helps clarify, because we want it to be as clear as possible.
Caroline.
I'm okay with the first one. I don't have a strong opinion on the second one, so if that's the way that the board is leaning, I can support that.
Thanks, Caroline. Diane.
I'm okay with both of those.
Robert.
I too am okay with both of them. I think regularly, given what Jeff's explaining, if you had something that could, in theory, could be scheduled and someone doesn't disclose it, an optional redemption, because it doesn't say. I think the clarification would be good. I'd like to see what. I get your point, Jackie, but I'm curious what language we're going to come up with if we're going to get tied in knots a little bit on the second piece.
Yeah,
But, I
maybe,
mean,
we'll let the team
yeah,
deal with
yeah.
the first one,
Yeah.
or maybe both of them, but maybe separating the sentences or something, but we'll let the team see what they can come up with. If we think regularly scheduled is helpful, like I get at some point in my mind, regularly scheduled doesn't mean anything different, but in Jeff's world it does. And so I'm sympathetic to that. I don't know if everybody's going to read it that way, but I also don't know that it's going to mislead anybody either. I don't think so. I guess I can be okay with putting it in there, but.
I think that would be my initial concern, is just whether that's a broad term of art or a limited term of art. I certainly appreciate the concept. Maybe the best way to communicate it, we could think on a little bit.
Okay, we'd appreciate that. See what you come up with. Thank you. So we're on paragraphs 9 and 10. We kind of dealt with the footnote a little bit. Diane.
Okay, so there were several GASAC comments that talked about move the footnote into the standard. I would be okay with that. I don't like footnotes, but that's just my own opinion. So, but I thought we ought to at least talk about that.
I will admit to not being a totally knowledgeable on GASB style guides and when footnotes are supposed to be applied and when they're not. My reaction to it was, especially with what we just talked about on the footnote, there's a little bit of a lot going on there. And to put that in 9A would affect the readability of the whole paragraph at that point to me. And so I would kind of leave it in the footnote, but I'm open. I'm not sold on that.
Well, I was thinking that, and in reading the footnote, that we could actually, if we were going to move it into the standard, we could take that first part that excludes the regularly scheduled debt service payment. But then that second part, we could actually add to part of the description in D, so that we're noting this could also include, these various things, the financing activities, and split it that way. So it's not just lumping everything into A.
That sounds a lot to me like we're now putting examples of D in, which was something we tried to avoid. We kept this list limited so that it wasn't a list. And you're kind of venturing back down the slope of what the standard used to say. And I would
True. Yeah.
like
No,
to avoid that.
No, that's true. And we did choose to take all those examples out. But I was just thinking it was a way of breaking down the footnote. And maybe it's more like a subsequent paragraph after that or something explaining it.
From the perspective, speaking to when we use footnotes or not. So footnotes certainly are authoritative gap. They're in the standard section. I think otherwise it's more of an art, not a science, maybe a matter of judgment. I think in this specific case, the risk, if they didn't read the footnote, the risk is that they inadvertently include something rather than exclude. So I don't know if that, affects your view of the placement of the information that's in the footnote currently. I think the staff tends to lean towards where Joel was going with the readability of it. Having all of that information in 9A seemed to maybe cloud the rest of the paragraph. But I think some of this is a matter of preference.
I think at least part to me might entail how you make the adjustments to the second part of the footnote. Because it really is now a hybrid about 9A and 9D. And when depending on how that looks, I may be more sympathetic to Diane's idea. Let's put it down as a sentence, not as part of D, but below paragraph 9, because it really relates to 9A and 9D, but we don't want to directly, because it's both, we don't want to put it in one or the other and have it sit and have the footnote just exclusively focus on the regularly scheduled. So, but I'm not totally wedded to that, depending on how it gets crafted.
I think my question would be, why are we specifically highlighting those as part of 9D when there are many other things that we would expect governments to evaluate in accordance with 9D. And so then this is like we're highlighting a certain piece. I do think the footnote is intended to be about 9A, right? But right now, perhaps it's that second part where the footnote's about 9A, but right now a reader is required to know that I have to keep reading to D and realize that these could also be part of D. And so I think that's what we would be attempting to clarify. But I would hesitate to put it connected to D in line with it or even immediately following, because I think that limits then D in a way, because you're highlighting these other specific things to be part of D.
It's not including it in D. It's describing what debt related means. Jackie.
So my criteria for something on a footnote is it essential for the person to understand what's being said? If it is essential, then it shouldn't be a footnote. If it's not essential, it's fine. It's just information. For me, I think that I agree with you, Emily. If they read debt-related transactions, they're going to put in debt-related transactions. They may put in more than you need to, but they're not going to put in less than they need to probably. So for me, I don't have a problem with this being a footnote. I do agree with you, though, that separating out the other debt-related transactions and highlighting them seems to indicate that our focus is more on debt-related transactions than anything else. whether it's part of D or in a subsequent sentence, I probably would have, I'd have to see how it looked. But I would be concerned that we're focusing them too much on that as opposed to other kinds of things. So I'm okay with it being a footnote, but I'm going to be interested in seeing how it reads after we play with it.
I'm where Jackie is, I think. I think Emily makes a good point about omission or what our risk is if they don't read the footnote. So, but the Gas Act did talk a lot about it. It's a good discussion, but I don't know if we have a majority, or maybe we just wait and see what the footnote reads like and then talk about it again. Robert?
I think I'm with Jackie on this as well. I mean, the way I was reading it all along is the footnote is illustrating what we're trying to define what a debt transaction is. And I'd be concerned about the focus, even though other long-term financing activities may be important. I would hope that governments would include them under 9D, but I'd be a little concerned that people would just focus on those and consider that definitional to the exclusion of other things that they should be considering for disclosure.
Thanks, Robert. Anybody else on the footnote or 9A? So I'm interested in what other board members think, but 9C, the change, I know what we were trying to do, but to me, we almost made it, to me, more confusing than I would have left it as we had it, with this being the option, because as I read that, I know what we're trying to say, but what I worry about is somebody reading a change in the composition of the legally separate entities. I know it says of the financial reporting entity, but I could read that to mean, did a legally separate entity within the financial reporting entity change its composition? Did it add a function? Did it add employees? Did it change how it's structured or something like that? And that's not what we're getting at, right? And we had some commenters that got that even from the way we had it, but I almost think this makes it worse, even though we were trying to solve it. And I'm open to other alternatives, but I would rather keep it the way we had it rather than the change that was proposed.
And we're happy to continue to look at that. This is maybe the no good deed
Right, for
situation.
sure.
You were trying to,
No doubt. You were trying to fix it.
yeah. And I see the way that you're reading it. And so we just need to be clear, or, the respondent feedback that prompted this change is addressed in the basis. So if we went back to what was in the exposure draft, that piece of it is also addressed in the basis. So maybe going back to what was there, if we can't come up with something else, this is all about how you read it, I guess, and where you put the emphasis on the words.
I mean, does anybody else share my concern, or Diane?
I agree with you. I think it gets more to what we're trying to say with the original language. I think flipping it around, it's not till the end that you finally figure out that you're talking about the financial reporting entities. So I agree with what you're saying.
Thanks, Diane. Jeff?
I mean, for what it's worth, I had a conversation with Emily about this point because I was tying it to the change to or within language that we use and we didn't want within, and we intentionally didn't say within, we said changes to. And so that was the linkage that, okay, I know what we're talking about, changes to, not within. And then when we changed it to in composition of, I'm like, what's that? But I did talk to Emily and she gave me that point of view. And I said, okay, I could get there, but I did struggle with that going away from the changes to language.
For that context, the changes to in statement 100 includes a change from blended to discrete, which that's what we're trying to exclude here. A change in presentation in a component unit is not intended to be included in 9C in this document. And that's what's addressed. That was the respondent feedback, and that was what's addressed in the basis. So we, with that focus and angle, changed the words, But I think then you can take if you look at it from a different angle, you can end up with Joel's view. So maybe either some different words or so we can explore that for the ballot.
All right. Thank you for exploring that. Jackie?
I was just going to say, I think that's a good idea because I had read it fine when I looked at it, but I can understand where Joel's coming from too. So,
All right. Carolyn?
Yeah, and I appreciate us wanting to be responsive to the feedback, but if we can, I'm in support of looking to see if we can reword it to get closer to what it was we really wanted to convey.
Thanks, Carolyn. Thank you, Emily, for that. Okay. Anything else on 9 or 10?
Not espousing an opinion on this topic, but there were,
Are you talking as Chris or?
I'm talking as Alan.
Okay.
I'm talking as me. I'm not talking as Chris. Chris is fine so far. Not espousing an opinion of this, but there were multiple people that talked about this distinction between a recognized subsequent event and a recognized event and a non-recognized subsequent event and a non-recognized event. I don't know if that's now's the time to have that conversation, but
Emily wanted to save that till the end.
okay, all good.
So.
All good. I just didn't, that's totally fine.
Anything else on 9 or 10? I think going once, twice. All right. Keep going.
Okay, we'll move into the notes to financial statements. This is for non-recognized events, paragraphs 11 and 12. And in paragraph 11, A and B, that is where you'll see the board's tentative decision to clarify this idea of non-numerical effects versus numerical effects, and that 11B is intended to be an amount, a numerical amount, which is why the words amount of the is incorporated. And then 11A reflects the idea that there could be some effects that are not numerical. And so that description should include a description of the effect in a narrative form.
Thanks, Emily. Board member responses to 11 or 12? Any comments? Robert?
On 11A, I go and I'm reading thinking about the deliberations, but then in the basis, it's clear that it's meant to be non-numerical, but is it explicit enough, or is it with including the amount in 11B, is that sufficient for people to draw a distinction or to understand that A is meant to be numerical and non-numerical? That was my question. Without it getting too wordy,
We certainly last meeting got into this last meeting or meeting 4, quantitative, qualitative, we had all this stuff. I personally thought this was really good, and but it is because I know and the basis, but to me, A, by standing there and saying effect, and then B, following up amount of the effect, infers enough that effect is broader. It could encompass more than just amount, but I thought so. I thought the team did a good job with that, but.
I mean, I can live with whatever
Okay.
it is. I just was raising the question. It's like, okay, if that's our intention. I mean, it's the balancing act that over time I'll probably get more comfortable with it, allowing people to use some judgment and that they actually read the standard.
Thanks, Robert.
I'll just say I was sort of, and I guess I'm giving this comment because we hear so much from GASAC, right, about, please make this as clear as possible, right, so they can be understood. And I did, as Emily will attest, I've been working this thing, and I had to be explained what this was meaning. Because when I originally read 11B, I'm like, well, what if I don't have an amount? You're telling me I have to, what am I going to have to do? I'm going to have to say I'm not making an estimate because I don't have an amount. So it was not clear to me what an amount there is code for. Well, if you don't have an amount, you don't have a disclosure, but we don't tell anybody that, right? We make you figure that out. And in the Gas Act realm, like, should we make them figure it out? Or should we just if you throw in if applicable, I would know what you're talking about. Because now it's, oh, I don't have, amount is not applicable. So therefore I can just ignore it and move on. So
Unless I'm not remembering, we didn't get any GASAC comments yesterday on this paragraph, though.
no, not specific, but I'm talking about the general rule
hear
of
you.
try to make the standards, as understandable as possible. And I would just say that in that realm, because when I read it first, I read it as, I didn't get that, oh, if you don't have an amount, you don't have anything to do. Because I was like, where's if applicable? Even when it was quantitative, I got it, right? But this one now is, I have to figure out like this amount of the effect. Oh, effect, amount of the effect. Oh, I don't have an amount, therefore I don't have a disclosure. Like I have to do some mental gymnastics to get to that. I get how we get there, but for the person who's just not living it, I'm not sure they'll always get there.
I think we did have a discussion, maybe brief, with the board about if applicable. I can't remember if the staff's recommendation in one of the earlier papers included that, and that, if I recall, maybe caused more confusion. What does it mean to be if applicable? Is that the context would be lacking there as well? If we take a big step back and think about just a preparer reading these requirements, is the information, if they read this, is the information that's supposed to be there going to be there? And I think that it will be. The risk, again, Jeff, I guess your issue seems to be more with 11B and someone saying, well, I don't have a numerical effect. This event doesn't have a numerical effect, and so I don't have to do B. I think that is a pretty common evaluation that preparers make with respect to any of our requirements and whether their circumstance fits into whatever requirement has to be applied. So I'm less troubled by that concern than like the other concern that we were originally attempting to address, noting that the description, even if there's a non-numerical effect, that should be information that users would want.
I mean, I think I don't want to put words in Robert's mouth, but I think that's what I heard Robert saying is first one. So it could be the flip side. Mine is focusing on amount in B, but then Robert's saying, I didn't get that it's both in A, right? So how do you, we were noodling with this quantitative and qualitative thing, but how do you, because if you read the totality of the two, you could then also think, oh, it's only amount in A, right? I don't have to give any description of a you know what I mean? Like that sort of thing. And that's sort of the flip side. And I guess that you're saying that's the trickier one.
Diane?
But it also seems like once you work through all the criteria and 9, that once you've landed on, oh, okay, I do have something here, and then you get down to 11 and, okay, so I have a description, here's my description. Oh, I don't have an estimate. You already know you have a non-recognized event. So it seems to me like it's just kind of intuitive how you work through it when you've identified that you have one in paragraph 9. So, I don't have a problem with the existing wording. I think it's clear enough when you put it with those criteria.
Thanks, Diane. Carolyn?
I think the existing wording does get to what we were wanting to get at. If you have a non-recognized event, then you have to give a description of its effect. And if there is a numerical effect, you also have to disclose that. If it's not, you don't have to go to B. Will just stop at A. So I don't have any problems with the way that it's currently worded.
Thanks, Carolyn. Jackie?
I too don't have a problem with the way it's worded. I read through it and I kind of well, I don't even I can get where we're trying to go. I think it makes good sense to me, the flow of the wording and the end result, what it should be. Like Diane, they already are going to know what the non-recognized event is going to be because they've already made that determination. So now they just have to figure out what the effect is. Is there a dollar amount? Yes or no? If there isn't, then just say there's no dollar amount, so I can't disclose that. I can't, that's my reason. So or whatever other reason they have for not being able to give an estimate. To me, I just think it flows well. I like the wording. I don't have a problem with it.
Thanks, Jackie. All right, Robert or Jeff, you're okay? Majority of us are moving forward, good with wording. Okay. All right. Anything else on 11 or 12? All right, keep going.
Okay, that will bring us to the last paragraph of the standard section, the effective date and transition provisions, paragraph 13. And you can see the change here is to remove certain language. And we talked about that yesterday with GASAC members. They seemed supportive of the change. Again, that was something that we were attempting to make clearer in the exposure draft. And it seems like it made it more confusing. So we'll go back to our standard language there.
Thanks, Emily. Any board comments on 13? All good there.
All right, we'll move into Appendix A, the background section, paragraphs A1 through A3.
Any board comments on Appendix A? No
Okay.
comments there, sorry. Other way.
We'll move into the basis for conclusions, Appendix B. We'll take B1 and paragraph B2 on the scope and applicability.
B1 or 2, board comments. No comments there.
Okay. Subsequent events, general section, B3 through B6.
Any comments B3 through 6 from the board? I don't see any.
All right. Recognized events, B7 through I guess it is just
Just
B7. B7.
Any comments on B7, recognized events basis? Diane?
This is probably just pretty editorial, but I thought the last sentence was really long, and I would split that into 2 sentences.
We'll take a look at that as we move into the ballot. We may have a couple of other edits to this paragraph generally, so we'll see how it all fits together. We have that one on our list, so thank you.
Thanks, Diane. Anything else on B7? That's all we got.
Okay, non-recognized events, we might have to split this one. Let's do B8 through 11.
B8 through B11. Anyone have bingo? No comments there.
Okay. B12 through B15, B16.
We may look at the end of B12, especially that last phrase is the composition of the reporting entity, and whatever change we make above may tweak that a little bit, but
And also just in that same vein, if we make changes to the footnote, we can take a look at whether how that flows through to the basis. So any changes that we make in the standard section, we'll do a check through the basis as well.
thanks. Anything else through B16? All right. No more comments.
Okay. Notes to financial statements B17 through B21.
Any comments through B21? Board. Continuing to move right along, Emily.
Okay. Note disclosures and comparative financial statements B22.
Comments on the basis related to comparative financial statements, notes. No comments there.
Next section, evaluating subsequent events and reissued financial statements B23 and B24.
Comments B23 through 24. Robert?
Just on B24, I just wanted to highlight, I think the way that you phrased it, I think helps clearly indicate what the board's intent on that is.
Thank you, Robert. We had a little bit of a GAS Act discussion on this one in particular and acknowledged that this was probably the best path. It seemed like most of them, even though they acknowledge it's hard too. So, all right, I think we can move on.
Okay. Considerations related to benefits and costs B25 through B29.
Any board comments on the cost benefit discussion here in the basis through B29? No board comments there.
Okay. And then finally, the effective date and transition paragraphs B30 and B31.
Any comments on the basis, rest of the basis? All good?
Okay, let's close out the appendices. So we'll take a look at Appendix C, the codification instructions.
Any comments on the COD instructions? That's a few pages.
The main changes that you're seeing specifically in the subsequent events section relates to the restructure of the standard section. So that's those are the primary changes.
I do not see any board comments on the COD instructions, Emily.
Okay. So let's talk about the terminology. This is related to the proposed draft includes the terms that were used in the exposure draft, which are recognized events and non-recognized events. We received some stakeholder feedback and then from GASAC members that submitted that stakeholder feedback that they would prefer the use of terms recognized subsequent event and non-recognized subsequent event. I'll provide the staff's view on why we chose to keep the words as they were proposed in the statement, and then we can open it for discussion. So I think there's two sort of foundational issues related to the terminology. So at somewhat of a conceptual level, the terms recognized events and non-recognized events have not been the ones that historically we've used to describe recognition. I think the staff's view is that events or transactions result in recognition. The recognition is of elements that are recognizable. We don't use those terms, recognized events or non-recognized events, in any other context in our literature. They're only used in the context of subsequent events. And I think our view, and it's somewhat reflected actually in how we've modified paragraph 7, even in this statement, is that the event itself the event itself is not recognized. It results in recognition. The approach, another piece of this is that the approach that we've taken is different from that of the FASB's approach. So in the FASB and in our literature in Statement 56, subsequent events, all subsequent events were one of these two things. They were either recognized events or they were non-recognized events. We've made a subtle shift in the way that we've approached the requirements in this statement. Subsequent events are an umbrella term. Some of them are recognized events, some of them are non-recognized events. And then there are also subsequent events that are neither of those things, that don't ultimately require any application of the guidance in paragraphs, in the later paragraphs of this statement. And so there is a little bit of a difference and a distinction. These are not the only two types of subsequent events. On a more maybe practical level, one of the reasons that we took a look at the feedback and thought about what it would actually look like to insert those words. And I think there's some concerns with the readability, specifically in how we've defined these terms in paragraphs 7 and 9. So we had some readability concerns. And then finally, we'll note that some stakeholders did request this change and others did not request this change or seem to have an issue with the existing terminology. The terminology comes from Statement 56. And I think we talked about this maybe in the very initial deliberations as to whether we should change terms, use entirely new terms. I don't know that if we were starting with this topic totally anew, we would even use these terms. But there is some history behind them. And so we ultimately decided to carry them forward.
Thank you, Emily. Board member thoughts on needing to add this? Not Jackie.
Not a thought right now, but would you reiterate the first comment you made about why we do or don't include that, please, Emily?
The piece about we don't use those terms. We don't use those terms in our literature as it currently exists to describe the things that are recognized. So recognized events or non-recognized events, that's not used anywhere in our literature. And I think the project staff view is that events or transactions result in recognition, but those things themselves are not what's recognized. They result in elements that are recognized, or they result in the recognition of elements. It's maybe a little bit semantics, right?
Diane.
This just made me think, will this have any conflict with anything that comes out of revenue and expense recognition? Because we talk about events and, we talk a lot about recognition. So I was just wondering if terminology, if it's going to somehow create some confusion when we get to that point.
I wouldn't think so. I mean, we talk about transactions a lot in that project and not necessarily events. And if something were to come up and we need to change this, we could always change it then. If it does seem to create, if that becomes a term we need there to use. But as Emily pointed out, we don't currently use that term to address anything. I don't remember that term really being used in our RER yet. And we'll say we're close to the end, but we're getting close to it and we haven't really seemed to need the term. But Jackie.
What you just said kind of went to why I asked Emily to repeat what she said, because I was thinking about that. And if we look at the RER project, the recognition going back to our model, relates to recognition occurs with the element, the model, the element. We have to recognize whether there's an asset or a liability. It isn't really founded on whether or not there's a transaction, whether there's an event that occurred. It's whether or not we've got an asset or a liability that'll decide whether we can have a recognition or not have a recognition. So that's why I asked you to repeat what you were saying, because I was kind of the opinion that, if they want this, not a big deal to me. Yes, we have recognized and unrecognized events that happen, but I hadn't put it in the context that you just put it in for me on when do we actually have recognition? Is it at the event level or at some other level?
Thanks, Jackie. Board member,
Just poking at that a little bit more. Why not? If I agree with what you're saying and what Jackie's seeming to agree with, but then can I sit here and say, we have the same problem when we say recognized events and unrecognized events. We're not, the insertion or non-insertion of subsequent events doesn't make the problem worse. The problem exists now. So if that is wrong, then we should be revisiting, or if we feel that that's not right, we should be revisiting the term, the terms in total, right? As opposed to debating it on the context of the, which I would be open to, but whether we insert subsequent events or not doesn't make the problem worse.
I would say maybe it amplifies the problem because it seems to suggest that those are the things that are recognized. I don't disagree. I mean, I think that's why earlier I was saying, the reason that we're using these words, there is a history to them. They're used in our existing literature. There is some familiarity by our stakeholders with this idea, and this is what they're called. If we go way back to before we incorporated this literature into Statement 56, because most of this originated from AICPA literature, these were called Type 1 and Type 2 events. That was their name originally, and you may be familiar with those terms. Then when we incorporated it, we adopted these terms. And so I think in the original initial deliberations, we decided we would stick with these terms because frankly, I don't know that we had a better alternative other than going back to Type 1 and Type 2. And this is what they are as they exist. But I don't entirely disagree that the foundational sort of issues I was describing have some relevance here.
just as a quick word search in the TBDs for the RER project, the word event is used one time in the specified details. It's not, transaction is used 76 times. They're category A revenue transactions. And as you've talked about, recognizing elements and the hierarchy and all this stuff. So we just don't use that term events in it.
We can probably thank our conceptual framework for that, which happened subsequent to when we probably adopted the terms recognized and non-recognized, because conceptual framework would say we shouldn't have used those terms to start with, probably.
I'm good with leaving it as is, for the reasons Emily has articulated. Robert?
I would agree.
It's Robert. Diane?
I can leave it as it is. I think the most compelling thing for me is that it's not used anywhere else in existing GASB literature.
It's Diane. Carolyn?
Well, I know early on when we first started this project, I was one of the ones who was in favor of just scrapping the whole recognized and non-recognized and starting over, seeing how we didn't go that route. And I agreed with the reasoning at that point in time. I still believe that we should stick with the historical basis and the familiarity that those terms would have with our stakeholders. So I would be in favor of leaving it as is.
Thanks, Carolyn. Jackie, you are leaving it as it is. Yes?
Well,
Okay, I was sorry. What do you think?
so until Emily brought this up in her first thing, I was going, yeah, I could go either way on this, but I agree with Jeff. Adding the word subsequent absolutely doesn't fix the issue. Yeah, so I don't see that change makes any difference at all. We do have a bit of a problem that it doesn't align with our conceptual framework at this point in time, but I guess I'm can't see us going back and starting over at this point in time either, because I think that it's more important to get something out at this point in time than to go back and say, yeah, maybe we should just relook at whether or not we should take Carolyn's advice in the first place and get rid of these two words right from the get-go.
Thanks, Jackie. Jeff?
I'm kind of where Jackie is. I wish I would have thought about this a little bit more at the outset. Seems to me we probably could have come up with some terms that would have focused on, you know, financial statement recognition versus disclosure and had them under those headings instead. But at this point, I'm perfectly happy not to be the deciding vote and sort of leave it as I don't think the subsequent is the source of my issue, right? And I don't think it'll make a big deal one way or the other. So I'm okay where we're at.
Yeah, I think people are going to understand what this is, given that they're in the subsequent event literature here. So I think we're safe to move forward.
Okay, thank you. We will move then, let's do the top of the document. So we'll do Roman numeral page 1, the summary and the table of contents. So the front matter. Any comments?
Any comments on the rest of the document? First couple pages, table of contents. No comments there, Emily?
Okay. Do we want to move to papers
Do
2 and
the
3,
papers
and then
first.
we'll circle back
Yes.
for the board's vote
Oh.
on moving forward?
That sounds great.
Okay, I'm going to turn it over to Joe.
Thank you, Emily. All right, so the second paper we have is cost benefit considerations for this project. I would note the board considered cost benefit considerations previously prior to the issuance of the exposure draft. Project staff notes that nothing substantial is raised to change the staff's views with regard to the conclusions relative to this topic. From a benefit consideration standpoint, some respondents provided general feedback related to the benefits of the proposed standard, including that they expected it will reduce inconsistency and diversity when compared to the application of the existing guidance for reporting subsequent events, and that they find the statement clear and easy to understand. In addition, other respondents did provide feedback for expected benefits as specific proposed requirements, which were considered by the board earlier this year during redeliberations, including the clarification provided by the definition of subsequent events and the subsequent event timeframe, clarification provided by the descriptions of recognized events and non-recognized events, and additional information to be provided in no disclosures about non-recognized events. From a cost consideration standpoint, some respondents did provide general feedback related to the perceived cost of the proposed standard, including that they believe the cost of implementation and ongoing compliance will not be overly burdensome. They did not anticipate increased costs resulting from implementing the proposed guidance. Furthermore, other respondents did provide feedback for perceived costs for specific proposed requirements, which again were considered by the board earlier this year during redeliberations, including concerns related to disclosing an estimate of the effect of a non-recognized event and providing no disclosures about non-recognized events at the reporting unit level. The project staff believes that some components of the proposed standard would mitigate implementation ongoing costs in this regard, specifically the prospective application of the requirements and the ability for the government to disclose the reason why an estimate cannot be made in lieu of providing that estimate for disclosures about non-recognized events. So the project staff believes that the proposals will result in more reliable, relevant, consistent, comparable, and understandable information about subsequent events. And the project staff also believes that preparers, auditors, and users will benefit from the enhanced clarity of the requirements. and that the cost of implementation and ongoing compliance will not be significant or burdensome. Which brings us to board discussion. Question number 1 for this paper. Does the board believe that the expected benefits of the requirements proposed for a final statement would justify the perceived costs of implementation and ongoing compliance? And the project staff believes that the expected benefits associated with the requirements would justify the perceived costs and ongoing compliance.
Thanks, Joe. Board member responses to the cost benefit question. Carolyn.
I agree that the benefits of clarity, hopefully better and correct application of subsequent event disclosures and consistency outweigh the cost of implementation. So I agree with the staff recommendation.
Thanks, Carolyn. Diane.
I agree with everything Carolyn said. I agree with staff recommendation. And I did want to add that stakeholders also noted that they did not see the costs as overly burdensome and did not anticipate increased costs. So there's benefits and not much cost.
Thanks, Diane. Robert.
Concur with the staff recommendation. I'll second Diane's seconding of Carolyn's
Thanks, Robert.
and her add-on.
Jackie.
I also agree with the staff recommendation and with everything my colleagues have already said.
Thanks, Jackie. Did Chris have a response here?
Yeah, Chris agrees with the staff.
Thanks, Alan. Jeff.
Yeah, I agree. Benefits exceed costs at the outset and believe that that equation will only get better over time.
Thanks, Jeff. I agree with the staff recommendation for reasons that are in the paper and that my fellow board members have stated. I think that there are, users have told us these disclosures meet our essentiality criteria. Disclosures have told us how they use it. It would be meaningful. With every standard, there's cost. I don't think they're overly burdensome in this case, especially on an ongoing basis, except for potentially adding the amount into the disclosure requirements. We intentionally, I think for cost benefit purposes, didn't set a practicability bar for the amount. We just said, if you can't do it, just estimate the amount, disclose why. So I think we provided a cost benefit kind of concession in a way there. And so I think we've considered costs as much as we can, and certainly there are benefits. So I agree with the staff recommendation here.
All right, moving on to the third paper, which is scope of authority. Per the Financial Accounting Foundation's policy, we'll begin with considering whether the information being proposed meets all of the characteristics of Group 1 of 3 groups of governmental financial information identified in that policy. And if so, then the information is within the scope of the GASB's authority and no further analysis of Group 2 or 3 is required. The board considered scope of authority previously prior to the issuance of the exposure draft. Project staff again would note that nothing substantial was raised to change the staff's view with regard to the conclusions relative to this topic. And so the 4 characteristics, the first being it meets governmental financial statement users' common information needs. Project staff notes that the proposals are intended to improve the accounting and financial reporting for subsequent events, thereby enhancing consistency in their application and better meeting the needs of financial statement users. The second one is that results from economic or financial events affecting users' assessment of government reporting of the governmental reporting entity. I would note that recognized and non-recognized events result from economic or financial events that affect users' assessment of governmental reporting entities. And the project staff believes that a final statement would enhance current guidance by providing improved information that is relevant, comparable, and essential to a user's decision-making or assessments of accountability. Third item is that it is relevant to governmental financial reporting objectives. And so as discussed earlier, the project staff again believes that the requirements will assist users in assessing accountability or making decisions by providing more understandable, reliable, relevant, consistent, comparable information about subsequent events. And the last and fourth item is that it falls within one or more of the following information categories included in general purpose external financial reports. It's historical or economic financial information recognized in the basic financial statements, disclosures in the notes of basic financial statements, RSI, and then historical financial supplementary information. And we would note that project staff believes that the requirements for recognized events meet the criteria for recognition in the basic financial statements as provided in Concept Statement 3. And the project staff also believes that the requirements for disclosures about non-recognized events meet the criteria for disclosing the information item in those financial statements as provided in Concept Statement 7. The project staff therefore believes also that the requirements are relevant then for economic or financial events recognized in basic financial statements and disclosures and notes of basic financial statements, and therefore meet the characteristics of general purpose external financial reports. So that brings us to the only question for this paper, board discussion question number 1. Does the board believe that the requirements to be included in a final statement will result in information that meets all of the characteristics in Group 1, therefore are within the scope of the GASB's authority? And the project staff believes that the requirements to be included in a final statement will result in information that meets all the characteristics in Group 1 and therefore are within the scope of the GASB's authority.
Thanks, Joe. Board member responses to the scope of authority. Question, Robert?
I would concur with the staff's recommendation based on the information presented in the paper.
Thanks, Robert. Carolyn?
And I agree with staff recommendation. The final statement meets the Group 1 scope of authority.
Thanks, Carolyn. Diane?
I agree with staff recommendation. I think Joe outlined it well, taking apart each piece, and it does meet the Group 1 characteristics.
Thanks, Diane. Jackie?
I also agree with the staff recommendation that we've met the Group 1 requirements for GASB's.
Thanks, Jackie. Chris's comments?
Yes, sir. He agrees that this is all Group 1 information.
Thanks. Jeff?
I agree too.
Thanks. I agree as well. I think you guys did a great job laying out all the reasons in the paper. And it's of note that the FAF's new executive director, Aaron, is in the audience. We take this scope of authority thing that's in our rules of procedure seriously. We've got a whole paper here about it. Following due process. Thank you, Emily. And Joe. So with that, all we got, we're gonna vote.
We just need your approval to move to a draft of a final statement.
Please proceed with a vote.
Jeff? I approve. Carolyn?
Please proceed.
No, you approve, right? Yeah.
I approve.
We got that conversation later. Diane? Jackie?
I approve.
Robert?
I approve.
And for the record, Chris was also in agreement.
Very good.
And Mr. Chairman?
Do you care about mine?
Mr. Chairman,
I approve.
thank you.
All right, Emily.
Okay, thank you. So we will bring a ballot draft of a final statement to the board at its December meeting. See you then.
Awesome. Making progress. Very close to the finish line. Thank you. Really appreciate all the work. Excited about this being close to done and look forward to the next meeting. With that, we will transition to our next topic, which is the implementation guidance update, which I think we can just change the team out. Give us a quick minute and do that without, a full-on break. All right. Guys are ready? All right. Emily had to slide over, and Lisa, I'm turning it to you, right? Correct?
Excellent.
All right.
Yes.
Implementation guide update, Lisa.
Thank you, Joel, and good afternoon, everyone. The team is very happy to begin the deliberative process with you on some implementation guidance for an update with some proposed new Q&As that we would issue or you would approve clearance for in the very early beginning of 2026. As you all know, Statement 103 has been issued. The effective date is vastly approaching for governments in 2026. So as a result of that, the hotline has been ringing with technical inquiry questions related to Statement 103, both from governments who are early implementing and others who are just trying to make sure they're gearing up and getting ready for the implementation of 103. And I think it would be fair to say for Roberta and I that the majority of the questions that we're receiving right now around Statement 103 relate to subsidies. So that's why you see here proposed 6 new Q&As and an amendment to an existing Q&A that we put in place in the 2025 implementation guide update that all relate to subsidies. So with that, we're going to walk through all 6 of the new questions and then also the proposed amendment to the question. Roberta and I are going to kind of tag team this. So I will lead your discussions through the first 3 questions, and then Roberta will take the lead for the final 3 questions. So the first one that you see in your paper relates to donations for scholarships, and specifically stakeholders that have questioned us in how donations for scholarships should be reported specifically by higher education institutions that report as business type activities or as enterprise funds. And it's kind of split, right? Because some stakeholders that have questioned us about this have suggested that they believe these donations for scholarships, even when there are no goods or services that are being received in return, might not meet the definition of subsidies included in Statement 103 because they believe that the availability of those contributions from the scholarships are not considered when they establish their public tuition rates. We believe that those published rates are irrelevant to the discussion here or the consideration of whether, in fact, those scholarships or the donations for scholarships are, in fact, subsidies. We believe that in these circumstances, both of the criteria in the definition of subsidies that we see in paragraph 14 of Statement 103 are met. And the reason for that is because the resources that are received are not for goods or services that are being provided in return, right? That donor of those scholarship resources is not getting anything from the higher education institution in return. And the effect of their receipt to those higher education institutions is that they are able to report tuition fees lower than they otherwise would be, right? So by receiving those donations, the higher ed institution is actually able to charge certain students. As we know, probably not every student gets a piece of these resources, but they're able to charge certain students a tuition fee that is in fact lower than it would have otherwise been without that donation. So hence you see the first proposed question and answer that gets at the heart of this issue. And what I would just reiterate here is that, remember, the actual published tuition rates, as was referred to, is really irrelevant here to whether or not these donations for scholarships actually meet the definition of a subsidy laid out in Statement 103. So the first question, as you see it, appears on the bottom of page 3, and the answer goes right through the top of page 4, which is a higher education institution that reports as a BTA or an enterprise fund receives donations for scholarships from individuals who do not receive goods or services in return. And the question is, do those donations meet the definition of subsidies in paragraph 14A of Statement 103? And of course, the answer, as I've already alluded to, is that yes, in those circumstances, those donations for scholarships that are received by higher education institutions meet the definition of a subsidy because they're received from the parties who have not received goods or services from that higher education institution, and they keep the higher education institution's current or future tuition lower than it otherwise would be. So with that, I'll open up that proposed first Q&A for board discussion.
Thanks, Lisa. Remember comments on question 1. Diane?
So I think the question and answer is good. I do have a couple changes that I would add. And I know Lisa made the point of saying that those established and published rates are not relevant to this. And I agree with that as far as the consideration, is it a subsidy or not? But that was the question. So I think that needs to be added. And so I would add it after the first sentence and say in the question part, and add the tuition rates did not consider these donations when they were established and published. So that that's really clear when you read the question that when it was asked, they were actually looking at it in that way. And then at the end of the answer, I would add statement 103 does not restrict this specifically to published rates, and the donations could impact future tuition rates, which goes back and ties to statement 103 and the criteria when you talk about subsidies, and that it could impact the future rates. So just a little bit of clarification so that it's not just reiterating what's in 103, but elaborates a little bit on what the question was.
So Diane, the team thought about your very issue and feels like we need to keep the question kind of narrow, right, to whether or not it meets the definition of a subsidy. But if you feel strongly about that idea of getting into the implementation guidance update, something about these published tuition rates, that probably a better way to approach it would be to actually add another question. And so the question would follow potentially right after this question and be something like, does that answer change if the published tuition rates do not change based on the donations that were actually received? And then, of course, the answer would be no. So that way there we would have two questions, but they would both be very focused on one issue rather than trying to have one question that's the be all end all for everything.
And I like that approach. I think that works. I felt like the original question and answer really just kind of reiterated paragraph 14 and the criteria. And it didn't add that extra. But if you want to do it as a separate question, I think it's worthwhile to dig into it a little bit, because there may be others that are thinking, oh, well, it's not in the published rates, so it doesn't count. So by getting that specifically in there in a second question, I think that works.
Thanks, Diane. Jackie.
I thought the question was clearly worded and I like the answer too, but I like what Diane is saying, because in my comments back to you, I kind of went with the idea too that in fact it could affect future tuition and rates because of the fact that they weren't having scholarships. It would affect in their enrollments and everything else. So I like the idea of two questions and going to the idea that not having scholarships could impact future rates, even if it's not relevant to the current rates.
Thanks, Jackie. Carolyn.
I support the original staff question and answer, and I also like the item that Diane raised. So I like the idea of calling out another question to address kind of specifically what was the issue that raises to the level of being included in the Q&A. So hopefully that makes sense.
Thanks, Carolyn. Robert.
Initially, Diane, when I was clear on your first part, but then the answer part I was struggling with, but I like the suggestion. So I would agree with the comment. I thought the original question was Q&A was good, but I think this is a good clarification.
Thanks, Robert. Jeff.
I don't know that I expressed it originally well to staff, but I think I had the same sort of view as Diane, and I sort of agree that the Q&A as posed doesn't do anything except reiterate what 103 says, and it doesn't give the background for what's the real question. My vote would be to amend it the way Diane suggested, because I don't see the original question doing anything other than just repeating what 103 says. If our goal is to give these higher education institutions the answer without any understanding of why the answer is the answer, then I think the original question does it. But if we think we want to give them some sense of why the answer is the answer for what they're thinking, my published tuition rates haven't gone down, then I think we could have amended it. I think you will achieve that with the second question. So I think that's okay. I still would wonder what the first question and answer are actually doing, because the answer is really embedded in the second question and answer, in my view.
Thanks, Jeff.
Jeff, I think part of this is if the fact is included in the first question and answer, then that's the fact set. So that makes it seem like it's a relevant fact, and that's the question and answer that you're answering. So in this circumstance, the published tuition rates don't change. If that's the only question that's to be addressed, then I guess that would be fine. But having the broader question, right? So this is the first question is kind of in all cases, donations for scholarships meet the definition. And then to get at the kind of specifics, well, what if my published tuition rates don't change? That's where the second question and answer comes in. So I think you might, if you combine them into one, you're limiting the fact set to start.
I think part of it may also, and I'm no expert in this, right? But when we had our discussion, and I think it says this it talked about, are your reported revenues lower? Right, your reported tuition lower. And when you described it in the analysis, right, you use that, but you didn't put that in the answer, right? So if you would say something like, my reported tuition is lower, then I would get like, okay, it's about what are you reporting as tuition? And that would be sort of getting more at what they're, but I don't know if that's the right thing to do, right? But
it might be
Yeah, it's-
future revenue.
They're
The-
indirectly
reported.
keeping the fees and charges lower, because remember, there's two pieces to that part of the definition of a subsidy, directly or indirectly. So this is kind of getting at the indirect.
Chris, have any comments?
no, he agrees with staff.
Thanks. Yeah, I agree with the original question and answer. I'm fine exploring a more specific second question to deal with the published rates, but I didn't, for the reasons kind of Emily was describing, I wouldn't have wanted to combine them, because to me, then we're narrowing the question. And, Jeff, you kind of said, well, this is almost obvious. Like, this isn't in the standard. The standard doesn't talk about tuitions and scholarships. And I don't think it's necessarily, I think it's helpful to have a broad question, this broad question answered first. And then if we want to deal with the specific published rates one, we can. So I find value in this Q&A as is, without adding in more specifics to it.
Great. So we will, when we bring the pre-ballot draft back to you at the next meeting, we'll include that second question for you all to take a look at that point in time. Thank you. So the second proposed Q&A relates to research grants, because we have been getting some technical inquiries from stakeholders regarding how research grants, again, from higher education institutions, and how they should be reporting these research grants. And I think the most important thing to note here with this one is that these are not a one-size-fits-all. All right, anytime we start talking about grants, they're really not a one-size-fits-all. We really need to focus in for these on the specific details of each research grant, because there's a whole lot of variability in the underlying details for these types of grants. So that's why you see in the proposed answer that we have here for this question, where we basically come at it from two ends of the spectrum, recognizing that there's a lot of gray area in the middle, but again, preparers and auditors will need to use their professional judgment in, making those determinations for these grants that kind of fall in the middle of these two ends of the spectrum that we're putting here before you. So what you basically see here in the answer is that it depends, kind of the answer that stakeholders hate to hear us say when they call up asking a technical inquiry. It depends. Well, in this case, it really does depend, because in the cases where the research grant is similar to a purchase of a good or service, what I mean by that is that the higher education institution would not engage in that activity. They would not incur those related expenses if they had not, in fact, received that research grant. So that's kind of one end of the spectrum where that would not meet the definition of a subsidy. That, in fact, would be an operating type revenue versus other types of research grants where the higher education institution uses those grant proceeds to actually offset some of their operating expenses, things like salaries, maybe lab costs, that would exist in the absence of those grant proceeds. They would still be incurring those types of expenses. In that case, it would in fact meet the definition of a subsidy, as you see in the answer that we provide here. So with that, I'll open up board discussion around this proposed Q&A. The question being, do research grants received by a higher education institution meet the criterion established in paragraph 14A2 of Statement 103 for purposes of the definition of a subsidy? And I won't repeat the answer because I've basically just given it in my it depends remarks. But there is one thing I did want to point out here that's a little bit different about this question, right? In this question, we're specifically honing in on that second subsidy criteria, which is whether the resources directly or indirectly keep that proprietary fund's current or future fees and charges lower than they otherwise would be. That's because, in our opinion, that first piece of the criteria about the provision of goods or services in these cases for research grants, it's kind of a slam dunk, right? We feel like most governments aren't going to struggle, and the TIs that we've received have really honed in on the second part of that subsidy criteria. So we've really narrowed it to whether or not that second piece of the criteria is met.
Thanks, Lisa. And I did have a question about the goods or services, so thank you for clarifying why. We just don't think stakeholders are gonna have a problem with that part, so that makes sense. Board member thoughts, comments on this Q&A? Jackie?
My biggest concern, I like the question, I like the answer, but my biggest concern is with one phrase that's in there in the answer, and that is used for activities that it would not otherwise have undertaken. As I mentioned in my response to the staff, faculty are extremely opportunistic. They will go after a grant that is going to help either supplant or supplement their salaries, which goes to the criteria directly or indirectly keeps costs lower than otherwise would be, because they are required to, in some instances, to help underwrite their own salaries. Otherwise, they're not going to remain employed. So it is, in effect, helping to supplement or supplant, reduce the university's costs. It's part of that's part of the requirement. So they're looking for any grant that will help with that. It's not necessarily whether it would be something they would otherwise have undertaken. So I think that the idea here is that it's more of a deliverable, a type A kind of transaction. We wouldn't consider that a subsidy. So I just think the wording probably needs to be worked on a little bit to help make sure that they're not saying, well, this activity we would have undertaken no matter what. So it meets the definition of a subsidy, and they're not going to clearly define or separate the two transactions that you're trying to identify in this. So that's my biggest concern.
Yeah, I think what we were trying to do with this, and yours may fall into the very large gray area, is that with the answer, we were trying to say, on one end, you have these clear-cut ones that are not subsidies. And on here, we have these clear-cut ones that are, and there's a whole bunch of gray. And I'm thinking what you're describing maybe falls in the gray.
Yeah, and I'm concerned that where you're trying to make the clear cut on the one end is going to be swept into the gray. And it's not going to be identified by the reader as your clear cut end of it is my biggest concern.
Do you have a suggestion for?
I haven't thought of a suggestion yet, but I'm happy to try and come up with something if you think it would be helpful.
Sure. Appreciate that. Thank you, Jackie.
Robert?
But Jackie's raising an interesting point in my mind. If the professor is encouraged or almost mandated to go find grants to subsidize his or her compensation or job, isn't that a subsidy? I mean, I think if that's the case, and if we want to get it more nuanced, and maybe it's getting it too complex in the context of the questions that have been received on the inquiries. I supported the Q&A as it was written in general. The one question I did have was on the second part is, what if the salaries and other costs that otherwise would exist aren't funded? I mean, the focus is on tuition in the answer, but what if there are it's not funded by fees and charges? What if there's other sources of funding that may be operating revenues or conceivably could be not operating revenues, things from endowments, or other revenues? How would that be treated?
Yeah, I think
What's on that?
that's going to fall in that middle area where it's not one of those two extremes, and the preparer would come back to looking at the definition straight up.
Okay.
Does it keep those fees and charges lower than they otherwise would be?
Right.
And if the answer is no, right, then it's not a subsidy.
Right.
No, I think you're saying just expand the types of revenues that we're talking
Yeah.
about that may
Yep.
be right.
I mean, yeah, because I mean, the answer is specifically talking about
The
tuition.
tuition just.
And there may,
expand it
if
to be
there's other
tuition and
operating revenues,
Yeah,
or I
yeah,
guess it could even be
yeah.
non-operating revenues.
Yeah, and I'll just say, obviously, we're not going to wordsmith these things at the table, right? But when we bring the pre-ballot draft to you at the next meeting, these changes would be marked so that you'd be able to clearly see them. Jackie, I don't necessarily think that helps your issue, though.
I think, and maybe I'm wrong on this, I think what we're trying to get at least the way I thought this is, the bar for a research grant to be operating is probably a pretty high bar. You're going to have to establish that there's no connection to anything that currently exists within your institution that would allow you to cover the cost, that connects you to that. And I don't think a lot of things are going to meet that bar. I think a lot of things are going to your point, the professor going out and getting a research grant to supplement his salary, that's not going to meet that criteria. So I thought about it as more about being that to get to it being operating, it's a pretty high bar, and you got to show that like there's no correlation to anything you do today, and you're going to do that, and the costs you're going to incur only related to that and solely related to that. So therefore, there's a correlation between the services you're providing and the money you're getting from the grantor. And so I was focused more on the bar to get to it being operating.
I've been trying to think about Jackie's point and Robert's too. And what you just said, Alan, helped me a little bit in that it's a high bar, but is it a totally unrealistic bar? Like, and I think that's what you're getting at, maybe, Jackie. If you would almost have to not have any faculty that are currently on staff be a part of the research. They would have to wholly be hired outside of this to meet the bar Alan is describing. And I don't know if that's realistic. Jackie.
So I think there are some grants. I mean, we've entered into some at the university where there's a specific good or service that is expected to be provided as a result of that. And to me, that's not a subsidy. So
That's
in those-
A1 and we're trying to focus on A2 here, right?
Right.
So-
So, I mean, to me, that's the only kind of a grant that would not constitute a subsidy, is one that provides a specific good or service. And there are grants that do provide specific goods or services.
So Jackie, are you saying then that condition 2 is always met? Is that what you're saying? Like is always going to be the case, and therefore then do we need this
Sounds like to
question,
me.
right? Because there's nothing they would not have otherwise have done. Because they'll do it. Conceivably, they'll do anything, right, to get the grant that would,
Well, I don't know that they would do anything.
But- but that's effectively what you're saying, right? That there's A2 is always met.
They look at whether they have the capability to do it, not necessarily whether it's always something they're interested in doing. They'll say, can I do that? Will I enter, do I have a chance of getting that grant? They'll apply for it.
So how,
In many cases.
how would you change it then? I understand you said you didn't have the word, but conceptually, how would you, what are you even thinking about when you're like, I got to change this, would not otherwise have done? What concept am I gonna introduce?
I'd have to go, like I said to Lisa, I'd need to think about the wording more on it, on what it is, but I think the way that it's worded, well, and maybe, I think the way that it's worded is going to cause some confusion on whether they should count something as a subsidy or not. I think that they're not going to clearly discern between what we want them to talk about and what they should be talking about.
Jackie was getting at is oh, so if you look at 14, if you look at pair 14, 14A is an and. You have to have both, right? So I think what Jackie was getting about the goods and services part, if it's a grant where I'm providing direct goods and services to the person that's providing me the grant, like direct goods and services, and you're not gonna get the does not provide. You're not gonna get 14A1. And then 14A2 doesn't become even something you gotta worry about. Problem is you gotta get to the point where there's not direct goods and services being provided to the grantor, and then you get to part 2, right? Which I think was Jackie was trying to get at, I
Yeah,
think.
but what I was hearing though is that, yeah, the question is really 14A1, and once 14A1 is no goods and services, then you're a subsidy because you're always going to be in 2. You're always going to meet 2.
So I think the problem is going to be, as Alan said, distinguishing whether they're going to follow the format and actually do that, or whether they're going to get confused by where does 2 come into my decision process in this. So.
But in fact, that may be a different Q&A, right? Well, I'd have to look and see what what you'd cook up, Jackie, right? Because then I might say, well, and then the question is really, the Q&A is really, A2 is always met with a research grant. And the question is really about, is A1 met? And that's the question.
I'm kind of where Jeff is, but Lisa, can I ask a question? Why? It seems like both the first question that we've already dealt with and this question, like the first question, we kind of put in the assumption that there were no goods and services provided. And here, instead of putting that as the assumption, we just do the same thing by only focusing on 14A2. But isn't that kind of a different way to get at the same thing? Or was there intentionally?
Well, we did it intentionally because in our thought was that the A1 was always met. So that's why the focus here was only on A2. But from what I think what I'm hearing Jackie say is that you think it's just the opposite.
I don't think that there's necessarily always a good or service that's provided to the other party. I think that in grants, that's not always necessarily true. The grantor doesn't expect a specific good or service. So I think they're going to get confused on that.
Yeah, and what we're saying is they don't provide a good or service, hence they're meeting that part of the definition of a subsidy, right? So we're not arguing that. We agree that that's usually the way it is.
But I think the way that it's worded, they're going to get hung up on that because you're saying, let's find the wording now. You're saying used for activities that would not otherwise have been undertaken. And I think they're going to get hung up on that and say, well, that means that would I have undertaken this or would I have not undertaken this? And I think that in some cases, they're going to not be able to figure out clearly whether or not they've got a good or service that's being provided, because you're not saying that it has to be good or service that is being provided to not make the clearance. The not otherwise undertaken is vague. It doesn't really address whether it's answering A or not. So maybe
But we weren't intending to address A at all. But I think you're saying they might conflate that with A. The way the words are there, that might be conflated with a conclusion about A.
Exactly.
And Lisa, remind me, I don't know that we were thinking that A is always met, but we thought that they would be able to make that determination. So we're focusing on the confusing part of the
A1, your guys.
yes, sorry, A1.
A1.
Yeah, I think what I'm gonna put words in your mouth. I'm sorry. I think what Jackie's suggesting, if I'm hearing her right, is the moment A1 is not met, you're not a subsidy. The moment A1 is met, you're always going to meet A2, is what I'm hearing her say. So what she's basically saying is they really got to understand, do you meet A1 or not? And the moment you don't receive goods and services, you're probably using current staff and current resources. Therefore, A2 is going to be a problem already. That's what I'm hearing her say if I'm listening to the way she's saying it, which means she is kind of putting the focus on the answer to A1 is everything in a higher institution realm, because there are times when they provide goods and services, therefore you're not going to get a subsidy. And there's times when you don't. And when you don't, you're probably using that to subsidize salaries and or overhead costs, whatever it might be. And therefore you're going to be a subsidy. So it kind of does all hinge on the A1 answer is what I'm hearing Jackie say. It's different than where we were going. This is different than what we were thinking, which is true.
This is great. So I think maybe the way we need to approach this is that we need to retool this question such that it's talking about, does it meet the definition of subsidies broadly, both pieces, not just honing in on that second piece of the definition. And then we would, of course, as a result of that, retool the answer so that it speaks to A1 and A2.
I think that's a great idea.
Sounds like that's a good idea to me too. Diane?
It also seems like if we're trying to contrast between what meets and what doesn't, if we could do like one paragraph in the answer that says, this is why it meets it and goes through that, and then another, this is why it doesn't, and then go through that. Because to me, it's kind of jumbled up on, okay, some of it meets it, some of it doesn't. But if we can clearly hit A1 and 2 in both scenarios, then that would help me.
It sounds like we've got some retooling to do here, but you have thoughts and the direction.
We will think more on that and come back with a more comprehensive, might not necessarily be part of the fact pattern in the question, but will be part of the answer that we provide to the question.
We will let you come back with something that addresses A1, 1 and 2 in a way, in some way, shape, or form. It addresses A for these research grants. Yes, A1 and A2. Okay. Very good. Thank you.
You're welcome. No, thank you.
It-
That one was a little bit different than the others, right? Because we did kind of take that narrower focus just because the TIs we've received were really specific to that one piece of the criteria. But all right, so that brings us to the third proposed Q&A, which was on passenger facility charges. As you all know, in statement 34, we did have that paragraph 102 specifically that was superseded by statement 103 because it was the paragraph that talked about allowing a government to establish their own policy as to what was operating. And as we know, that went out the door when we introduced the definitions of operating and non-operating in statement 103. But in that paragraph, we had in a parenthetical at the very end, an example, and passenger facility charges were included there, that they were non-operating. They would be considered non-operating. So as a result of that, we've received some stakeholder questions as to whether or not, now that I'm implementing statement 103, will those passenger facility charges still be considered to be non-operating revenues, i.e. meaning they meet the definition of a subsidy. So the big crux here to this whole question and answer is that you have to buy into, in order to agree with this question and answer, you really need to buy into the fact that the airport provides goods and services to the airlines. The airlines provide goods and services to the passengers, right? So if you buy into that mentality, that's what this Q&A is aimed at clarifying, that as a result of that, passenger facility charges, because they're paid by passengers, right? And those fees are collected by the airlines, but then get funneled through to the airport, that they are in fact meeting the definition of a subsidy because the goods and services are not being provided from the airport to the passenger who's actually paying the passenger facility charges. So that's what this whole Q&A is meant to clarify for airports, is that yes, these passenger facility charges would in fact meet the definition of a subsidy as it's put forth in statement 103, and therefore means no change for them because they're still going to report these passenger facility charges as non-operating revenues, which is what they do today based on the guidance in statement 34. Yes, if that money is used for capital purposes, then that would mean it would be a capital subsidy, versus if it isn't, then it would be a non-capital subsidy, which, as we know, changes up the geography on that flow statement as to where in fact they would be reported. So with that, I'll open up for board discussion. The third proposed Q&A related to passenger facility charges, which is, do passenger facility charges meet the definition of subsidies in statement 103? And of course, for all the reasons that I just said, the proposed answer is that yes, they do. One last thing that I will say on this one, this will be an important one where we don't necessarily want to wordsmith it at the table. We obviously got some of your feedback prior to today's meeting, and all of the pieces are there, but we're hearing you all that maybe they're not packaged in the clearest way, because it seemed like some of the board members wanted to add clauses to various sentences that were in the next sentence or the sentence after. So we're aware of that. We're going to look at this to make sure that we have that answer packaged in the clearest way. But certainly a preparer or a stakeholder would need to read this from start to finish in order to get all of the concepts here that I've just discussed in my opening remarks. So with that, I'll stop talking and open it up for board discussion.
Thanks, Lisa. Diane.
Okay, so I was one of them that added an additional clause. When I read the answer, I felt like when I got to the second sentence and it talks about passengers receiving services from the airline, it's when Lisa talked about all of this and said, you know, they're not receiving goods or services from the airport, and the passenger facility charges are going to the airport, but then we throw in the receiving services from the airlines. And I thought that part was kind of confusing. So I was thinking we needed some clarification in that area about, no, they're not receiving goods or services directly from the airport. And to go with that, passenger receiving services from the airlines, because I thought that was confusing, but otherwise I was okay. And I'm good with what you said about splitting the two and everything, but I just think that needs some clarification in there.
Thanks, Diane. Jeff?
So at the risk of annoying some people, I just want to think through this notion. I understand it took me a while when I was reading it, but I got to what Lisa described, the services provided from the airline to the passengers and the airport to the airlines. But as I sit there and say, if you talk to most people and ask them, do you get any services at an airport? Wouldn't passengers believe they get, I mean, do you not get, when you go to an airport, you get no services from the airport? You don't get a chair to sit in, you don't get a water fountain, you don't get something from the airport. Now, if we want to get to that conclusion to get to the answer we want, I get it. But I do think that I struggle with the statement that passengers get no services from an airport, that the airport's sole service is to the airline. I do struggle with that, and I just wanted to maybe have other board members help me alleviate my struggle.
So is it not more the notion that the passenger facility charge has nothing to do with the goods or services the passenger is receiving from the airport? Because the passenger facility charge by federal statute has to be spent on capital projects, most of which are facilities, but one of the allowable projects is land acquisition for noise mitigation. So the airport could collect these passenger facility charges, acquire a bunch of land. The benefit there is to the people that live around the airport, not the people that are coming on and on planning the thing. So I think it's not that they aren't receiving any services. Maybe there's a concession there where they went and bought food or whatever. It's just, it's not related to the passenger facility charge in any way.
That would make more sense to me, right? That there is no good, so for the passengers paying the PFCs, right, they're getting no goods and services for those PFCs. Those goods and services are going to they're getting other services from the airport, but they're not paying for it through the PFC. And so that nuance, to the extent we could communicate it, would make more sense to me and would sort of ground the answer so that future people could understand what our rationale was in getting to the conclusion that we reached, versus if we just said there's no services provided by airport, I wouldn't quite, my confusion would reign, right? So I agree with you.
Is that a fair assessment, what I said?
Yeah, and I think that was our intention with including that first sentence in the question, was to really lay the foundation that, hey, the feds really restrict how these funds can be used. And generally, as Joel said, they are used for capital. But if you read that description, we didn't call them capital because technically, you might meet one of these enhancements without it being capital. But we know from talking with some of the airport folks that generally these passenger facility charges are in fact used for capital purposes.
I agree with what Lisa just said. Jeff, I think part of it was a little bit, I'm starting to learn that the deal with these Q&As is to keep the fact set as clear and as tight as possible, because once you expand it, it gets hard, because as we know, airports have other revenue streams. They have leases for their concessions. They have parking lot revenue, they have other revenue streams. But those other revenue streams don't have anything to do with this question, because the question is about the passenger facility charges and whether or not they're operating or non-operating revenue. And so in that sense, to Joel's point, most of that's noise abatement, runways, taxiways, all those capital kind of things that really benefit the airline more than they benefit the customer, which is how we get to the idea of like, no, those things are really airport for the airline, airline for the passenger, which don't have anything to do with how much Starbucks is paying LaGuardia to have a Starbucks in the building, because that's a totally different revenue stream that we're really not actually talking about, right? And so in my mind, I'm separating all that from the other, but that's not in here because I was trying to keep this fact set just to that one revenue stream. And is that revenue stream a subsidy or not? Right. And then when you think about what that subsidy is used for, noise abatement and runways and taxiways and stuff, it's like, that's really for the airline. It's my brain of logic.
It's not runways or taxiways.
Do what?
It's not runways or taxiways.
Well, not capital.
But
Capital.
it's-
You know that's the way better than I do. Sorry.
I would also, I mean, it was one of the suggestions you may consider editorial. That first one, instead of summarizing what it could be, I would just say approved by the FAA for eligible projects under statute or whatever, but Carolyn,
This one took me a little bit to get through. I didn't have my issue, not issue, but I had to really read and think about it to get to the part B as far as the keeping the fees lower than what they would normally be. Having had this conversation, and having, reread the paper, I do agree that this is a good Q&A to be included for exposure. And hopefully it will provide some of the stakeholders clarification to help them get to the right conclusions. But so I do agree with including this Q&A.
thanks, Carolyn. Jackie,
I was where Jeff was for a little bit going, yeah, what do you mean they don't provide any? But when I went through and relooked at it and talked myself through all of the pieces and put them all together again, I came out with, yeah, that works for me. So I'm fine with the question and answer the way it is. Although I did have the same hang up that Jeff had until I went through it a few times and talked myself off the ledge.
thanks, Jackie. Robert,
I'm fine with the Q&A as it is. I'm sitting here trying to wordsmith that sentence where they have not received goods or services, if that's the kind of the hang up. But I'm not coming up with any words that would not go down a rat hole that we really don't want to go down. I mean, not received goods or services directly. I mean, I think if preparers and users understand what the folks working in the space know what passenger facility charges are for. So I think this is a good clarification to ensure that that's what they're, I mean, fees, I mean, one of my questions was, are fees from the airlines only used for capital projects? In other words, because that's the PFCs are using to reduce that. There may be other fees airlines are charged by airports, but the focus is on the capital side. So I think we're fine.
it's Robert. We have your thoughts, I guess. We'll see.
I mean, I think
Some
there,
words that might change.
to Robert's point, I think there is, I could contemplate a change to the second sentence, an addition to the second sentence of the answer, right? Where we say the passengers receive services from the airline through which they purchased the ticket and not from the airport, from the PFCs. So then you'd be saying clearly they're getting the services from the airline and not from the airport through the payment of their PFCs, right? So now I'm making clear what we were talking about before. And I think that's a comprehensible type of.
Suggestion.
Yeah,
for the
that,
team.
Jeff, we've made note of that suggestion. That's one thing that we will consider when we look at the rewrite of how that's all packaged together.
Chris, comments here?
Chris ultimately is okay with where we are on this question after some conversation.
Is your thing on?
Chris ultimately is okay with where we are on this question after some conversations between him and me and you.
He had similar.
He had some
concerns
he had some
expressed,
questions.
but as I explained how these things work, he agreed then with the Q&A.
I mean, I do think it's important that we do have this question because I will say, and I was talking to Abel about this just yesterday, that you do have airports that show this is currently operating. You also have airports that show this is not operating. And part of this was to get consistency in what is operating and not operating. And part of that is just have an interpretation of how do you consider these in terms of who's providing goods and services to who? And so that's why this question is important in doing that. And so there's an understanding. So we've been talking to the airports about this answer, about this Q&A, about the results of it. So they are aware.
I was good with the Q&A. I've given you a couple of editorial things that you'll throw into the mix, but it was just for clarity purposes. It wasn't fundamental to the question. So.
Great. Thank you very much. We'll move on to the fourth question.
Okay, moving on to another industry within our many BTAs. On to housing authorities. We are talking about grants for housing vouchers. It seems like each of our industries have something unique going on in them, which is why we're having these various series of questions about. And so housing vouchers is an arrangement where the federal government provides a grant to housing authorities, and housing authorities funnels that to individual grant recipients to provide a subsidy for housing for them. And so we provide, and that's something where they have raised questions to us about how that should be presented. It's my understanding that a lot of them are presenting that as operating at the moment. So they're probably not going to be excited about the answer to this question. In the past, they've had the ability to establish a policy. So they've developed a policy that somehow puts that into operating for them. But the point of 103 was to have guidance where everybody would be putting things in the same place. So they wouldn't be establishing a policy, they'd be following our guidance. So applying our guidance, we developed an answer to this question that they asked. Sometimes one shouldn't ask, but anyhow, so we have answered the question about grants. It seems pretty basic. It didn't seem like there was much of a question about how one would answer this. Related to grants for housing vouchers. So we have the question, do grants received from the federal government for housing vouchers meet the definition of a subsidy? And the answer is pretty clear that it definitely meets the two criteria for meeting the definition of subsidy. So with that, I'll answer question 4. Do you have any questions or comments about the question related to vouchers for grants for housing vouchers?
Thanks, Roberta. Be careful what you ask for.
Yeah.
Just might get it. Board member comments here. Jackie.
So I did have a question to the staff on this one that maybe they can clarify for me. I was unsure how it was meeting B, that it allows the housing authority to keep current or future fees lower than they would otherwise be, because my understanding of vouchers where they were kind of like a pass-through. It goes to the housing authority, but it's got to be passed through to the individual. I didn't think it really affected the housing authority's costs, but maybe there are administrative revenues or monies that come along with the vouchers that help keep the housing authority's costs lower than they otherwise would be.
Well, it's kind of, it's more of a general statement, let's say. This is a kind of a I don't know, a tougher one, because it's really a bit more of like a governmental program, but it's a more of a generic indirect type effect. You're right. It is something that has much more of an indirect nature to the effect. A lot of housing authorities also have, they're subsidizing, they have properties they operate, you know, and in effect, you're right, on the admin side, there could be some potential effect of reducing the admin associated with those type of things as well.
I guess, Jackie, is not how I thought these worked. So if you're an eligible participant in like Section 8 housing, the government has determined that you're an eligible participant. You have to contribute whatever it is, the percentage of the rent that you can afford. And then the housing authority pays the balance to the landlord. So the landlord or whoever, which could be the housing authority using its other funds, if the housing authority owns the property, I guess, which is happening less and less, but does happen, it's using its other funds to pay the rest of the cost of operating that facility beyond what almost kind of clearly the rent wouldn't cover.
I can clearly see that where if the housing authority owns the property, and the vouchers help keep their costs in line for what they would have to come up with out of their own budgets to cover the costs. But I was unclear unless there's administrative monies that were involved with the program, because I can't believe that the housing authorities are making up the difference on paying a landlord between a voucher payment and what the rent would be for most of these, because I don't think they have the budgets to do those kinds of things. So I was just unclear how it would actually directly or indirectly affect, but I can see where if the housing authority owns the property, I totally agree with the answer.
Having rated some of this stuff in a prior lifetime, I think it's an important point, and I think we ought to be clear about the point Jackie's raising. Well, what do we mean by, because a lot of this voucher now is tenant-based, not project-based. Is the housing authority owns it, and they've moved some away, and now it's tenant-based, so it travels with the tenant. And so how are the rents sent? The rents are sent by HUD. So HUD determines fair market rents for every zip code in America. And they determine the rent, and then the calculation is made. What can this tenant afford at 30% of their income? And the voucher will make up the difference. And the landlord will accept or not accept fair market rents. If they want them in their building, they'll accept them, but that rent is set by the federal government. So when we say it keeps the fees lower than they otherwise would have been, what's the fee, right? Because the fee, if that's the rent, that's set by HUD in these cases, right? So I'm not clear how it's lower than it otherwise would be, because the voucher just expands to make up the difference between what the tenant can pay and what the fair market rent is. So that's a harder one to get. And even in the project base, then you're like, well, if I think those fair market rents are going to be what the housing authority owned project's going to charge too, and the same thing. It's going to be the voucher, the project-based payment is going to be the difference between what they can afford and what that rent is set at. So there's nothing for them to lower. Right? What's set is your income is what you can afford. That's set by the individual person, and the rent is set by the federal government. And there's nothing that the housing authority actually determines other than those two things, right? So I'm not sure how that.
Diane,
Well,
sorry, and then
have-
Robert.
Having been on a board
Oh,
of the
yeah.
housing authority, see, I saw this as, okay, this is one less person we have to place into some place and be paying for it. So it avoided expenses that they would incur. So that's how I was seeing this, that the voucher would place the person, that the housing authority wouldn't have to pay for the rent for that person, because the voucher would pay for it.
Robert.
So in that instance, I would agree with the question, but the other thing I was thinking as Jeff was talking here is we're talking about a public housing authority that reports as a BTA or enterprise fund. If it was not, I'm having trouble conceiving, and by no means am any expert on housing authorities, why would they be reporting as a BTA or enterprise fund if they didn't own the housing project? If they were just somehow involved in some administrative activity to help people be placed in housing and the vouchers going directly to the private property owner as the landlord, why would they be a BTA? Wouldn't that,
I think that what you see mostly is you see housing authorities that do both because they're
Okay.
converting, so they still have some old school
Okay.
and they're converting into the new school. So they're probably they were originally set up as a BTA because they largely owned them, and
Right.
now they're converting, but they still have some of both.
And there's a long history of HUD encouraging reporting as BTAs.
okay.
As HUD expects the reporting the housing authority does to HUD to be as a proprietary fund.
Proprietary fund. Okay. I mean, I was fine with the question as originally raised, because I think I was looking at it in that very granular understanding in the context of the owning the facility that's being rented. And so whatever the housing authority would be garnering in terms of rents from the tenants otherwise would be lower because of the vouchers. But I think there's obviously other nuances here.
Do kind of wonder if either we have two questions or we get this one more specific. It feels like we need to be clear of does the housing authority own the facility that these vouchers are going towards? And in that case, what we have here is fine. It's maybe less clear what happens when it's a pure voucher program. Then you have to start getting into Diane's way of thinking, which I'm actually kind of trying to wrap my head around a little bit, and probably need a little time to think and process on as to whether we have a second question about those.
Joel, can I ask you a question?
Yes.
The housing authority is providing services to who? The tenant? Because I believe that's, if I believe that's
You're
they're providing,
you're in the second scenario, right? Where
which is
third-party landlord owns a building that's qualified as, yeah,
secondary housing, and the housing authority is providing the services to the tenant. So the resources are getting from the federal government. Services aren't being provided to the federal government. The services are provided to the tenant. You're going to fail 14A1 right off the bat. So it's a subsidy. It's a subsidy right then and there because it's the resource provided aren't related to goods and services being provided to the person providing the resources. So if you think the resource provided by the federal government or for goods and services not being provided to the federal government because they're being provided to the tenant, you're going to fail 14A1.
And I was going to say my knowledge and experience has been that the tenant does benefit because their rent is lower than what it would be otherwise because they're getting the voucher. So they're going to be paying a portion of the rent out of their own resources, and then another portion is covered by the voucher. So, and those are, in my experience, the housing is owned by a third party. It's not owned by the housing authority.
I only brought that up because Jackie was kind of honing on the second part of the answer. And what I was getting to is the first part of the answer, which is kind of the thing back. We're kind of a little bit back to the research grant conversation, right? Because, and maybe even the PFC one, if you think the services have been provided to the tenant, then there's no goods and services to be provided by the housing authority to the federal government who's providing the resources. And so you're going to fail 14A1. So 14A2 or whatever that number is, doesn't even matter.
so they're not subsidies.
No, there are subsidies. Resource provided do not relate to goods and services provided by the person. The money being provided do not relate to goods and services being provided by the resource provider. So the services do not relate to goods and services being provided by the housing authority to the federal government because the federal government's the one providing the resources.
So it meets 14A1.
I always
not
get it backwards.
fails it.
I say that.
Yeah, I
they-
know.
They correct me the whole time, Joel. Sorry. I mess this up every single time.
It's me.
I'm sorry. You're correct. I'm sorry because The three of them have corrected me like 100 times in the last 2 weeks on this, on the way I say this. I say it wrong every time.
Say it the right way then? Like what? Because my brain is in pretzel for a minute.
Yeah, but if the proprietary fund, the housing authority, is not providing goods and services to the federal government, because they're providing goods and services
Right.
to the tenant,
Okay.
right? So when they don't provide goods and services to the resource provider, it's a subsidy.
Well, no,
gotta
you've
meet
got to,
two.
you've got to meet two as well, right? And so that's
So-
the question. 'Cause
Right.
you have
So
to
my
meet,
question is.
yeah.
In the tenant-based, what's the current or future fee that the housing authority is keeping lower? If
And
the
that's,
federal government determines,
and that's kind of Diane's comment,
if,
right?
if the federal government's deciding the rate and the federal government's deciding what the tenant pays, what is the housing authority, what are they changing?
But if they're providing services to that tenant and they get the voucher, then that's the service they can provide without having to spend any money on it. So they can spend money on the next tenant that doesn't get a voucher. So it subsidizes the fees that they're paying.
This is where that indirect word comes into play again, right? And the fuzziness in the fact that Robert was bringing up, that if they're reporting as a BTA or a proprietary fund, right, then they should be charging a fee or charge, right? That's the whole premise under that fund type. So just keep that in mind.
Yeah, but my experience is that I think you're making a supposition there that if I'm a housing authority and I get these vouchers, if I don't have vouchers, you're on a wait list. Right? You don't get any services. You're on a wait list, right? Because I don't have any money to give you services. The only services I can provide you are through the vouchers. And that's why these housing authorities have wicked long wait lists, right? Because they don't have any resources other than through the voucher program to provide housing for these folks, right? So you're making an assumption that they would, okay, no voucher, I'm going to go into my own pocket and I'm going to find you housing or pay for your housing. And you think the reality is housing authorities just don't work that way because they don't have any other sources of funds.
They have a lot of sources of funds. Well, yeah, okay. Okay, the one I'm familiar with.
So where are we?
I feel like, to me, we have a question that looks a lot like the question that's there, that is a added in situation that the housing authority operates,
What?
owns the building,
Oh, what?
right? And then there's maybe another question that I'm not sure that we workshop that's housing authority doesn't own the building, and how do you handle what Jeff and Diane are talking about?
I'm not understanding this, the subtlety here. There's three questions?
Two questions. One is the situation where you get the housing authority gets a voucher and it's helping to supplement the cost of them operating the building and housing the tenants they have in
Okay,
their
that's
building.
the rare 5% of cases.
Okay. Then maybe we don't need that question if
Okay,
that's,
yeah.
if
At
those
least,
don't
based
function.
on the housing authorities I've spoken with, which again, it's not representative of all housing authorities, just the ones I've encountered.
Okay.
But
The ones you're
mo-
talking about, Roberta, are ones where they don't, there's private owners.
Right,
of
right.
the-
That's
so
that's
they're
the
just
ones that
providing
I've
the
worked
voucher
with
to
most-
the
yeah,
tenant. The
yeah.
tenant goes and gets the housing and pays it. Right? So then I would say, how does that meet A2? Because the housing authority, they're not, there's no fee or charge they're keeping
Well,
lower.
if they've gotten the fee down to zero is the point.
Would they have ever paid the fee in the first place?
We would have to say yes, because they're reporting it as a proprietary fund or a BTA, right?
Except, are they legacy or are they not legacy?
But who would they be charging? Who they, in the non-owned facility world, which you're saying
I
is
know.
95%.
How would they charge for a voucher, right?
Yeah, how do they charge for a voucher? Now my head's going, and this kind of gets back to why they
I know,
accounted for as a
would you
BTA,
take to the
because
alternative of pulling the question.
Hmm?
If it's too troubling that, except for the fact that there are housing authorities out there that,
that are raising,
Mhm. I mean, maybe it gets to that this is too much to do in a IG. Again, danger in asking the question.
And what we're trying to do, Robert, is a situation where we have housing authorities out there who are asking us the question of how to record this as operating or non-operating revenue, and they have no other revenue stream,
Mhm.
none. So their fees and charges are basically zero. And we're trying to not to ask the other question, which we're trying to ask is, the one we're leaving alone is, are you a proprietary fund? But they are reporting as one, and they've historically reported as one. And
well, is that because historically they had these, I mean, most or many had these facilities, they were operating them, and over time, the nature of the assistance being provided by the federal government has changed, where they're not long, they're just in effect a pass-through, but the legacy is they reported it as a proprietary fund or BTA because that's what HUD liked, or that's what they want, but times have changed. And that's a whole other can of worms I'm not sure we want to go to.
Sure, and we don't have guidance that says you need to reassess your ability to use a proprietary fund every year. Something decision made a long time ago.
All right, let's pause on the revenue side. If the housing authority receives the voucher from the federal government and it provides the voucher, the funds, to X-owned tenant, landlord, what's the outflow? Is it operating or not operating?
We would say, Joel, if it's a subsidy, then it has to be non-operating.
Yeah, I mean, you read 14B and it's, are they recoverable through the proprietary fund's current or future pricing policies? And we're saying, well, they don't really charge anything. They only are passing through this money in essence.
But could they charge a fee?
Wouldn't that depend on how the government is operating?
Yes.
They don't have a fee.
No, but I mean, could they?
No.
The voucher brings it to zero.
When you say the fee there, Lisa, what are you talking about as the fee? I mean, if, because I'm thinking about it as the choice, if I have a tenant that I want to help and the voucher from the federal government enables me to pass through the payment, now I don't get the voucher. Now, that would mean for that tenant to live in that same unit of privately owned housing, they would have to pay more, like what Diane's talking about. The housing authority would have to come up with the money because the rent is the rent at the privately owned place. I don't got voucher money. I have to now pay
So,
subsidized, and that tenant can only pay 30% of their rent. So that subsidy would have to come from
right, so,
me.
for a proprietary fund to make a subsidy, it has to come from its fees and charges, right? So you think of like a utility, it charges more so that it can subsidize some other operation like the general fund. So if you're thinking housing authority, what's its fees and charges? It rents, right, you'd have to charge higher rents so that it can subsidize something else. So it's kind of hard in a housing authority model to think of it subsidizing things.
Right, unless you
Mhm.
thought that there was a housing authority out there that had some, and even then, I don't even know that they have the ability to do it because they're creatures of HUD, right? Because I couldn't say I have some owned units of housing. I would charge more for the tenants on the owned units so I can make a little money that I could then
Yeah, no,
subsidize
yeah, so
these other non-unit based people. But I don't even think they have the flexibility to be able to do that because they don't determine the setting of the rents. HUD does.
right, so it's struggle.
Yeah, I happened to pull up a housing authority financial statement, and currently the largest line item in operating expenses is housing assistance and operating subsidy payments. Right, they called it a subsidy within their operating expenses.
Well, the ones we've talked to, I think they would say that they want the revenue side to be operating revenue because the expenditure side is an operating expense to them currently. And so their fear is that the inflow becomes a non-operating revenue with an operating expense, and now they look fully subsidized, which some folks might say you are. But I think they think that that's how it would result, is non-operating revenue and an operating expense, and that's what concerns them versus what they've historically done. And historically they've probably shown them both as
So if I have a housing authority, all I do is this. Who pays for the person or whoever that is administering the program?
Different kind of grant. Admin grant.
Which would also be a subsidy.
Yep.
Which gets to Robert's point a long time ago, that if that's really all they're doing, the problem is we're trying to put proprietary accounting into, or they're trying to put proprietary accounting and their choice into a governmental program model. So then it just comes down to how does it meet these definitions?
Can we do this? Can Steph and I go back and think about how we deal with Part B? And there's a part of it that says the Robert issue is causing such an issue. There's a question is like, should this even be a question and just be how we respond to TIs when the TIs come in? And this isn't an answer because the answer is trying to articulate how your fees are adjusted in a world where you're a proprietary fund with no fees. And maybe that's not something we should actually be trying to solve in writing. And maybe that's just something we should be dealing with in a TI. And maybe let us go back and see if we can come up with a better worded rationale for why B isn't met. And if not, it just needs to be, this is policy for how we're going to answer TIs related to this. And it's not a written down answer. Because we have struggled with his exact scenario the whole time we were trying to write this. And we can either, in the next version of this, either bring you back a revised answer to Part B or explain that we weren't able to. It's just my thought. I don't know what the board thinks, but that's my thought. I saw a lot of nodding by staff, so I think they're
Board member thoughts to Alan's proposal?
Just so I understand now, so you're suggesting there's a way you think we can get to where part 2 is met? Or you're going to say, I don't think we can get to that.
What I heard Alan say is, we're going to try, but he's doubtful.
And we don't want to pull that threat
Well,
of the fun type. And so yes,
I,
right.
I think what I'm
That's-
worried about is going into a world we put on paper an idea that, yes, you can be a proprietary fund. No, you can be a proprietary fund without fees and charges. And we almost might be indirectly saying that here. And that worries me a little more than, we can't get a better answer. We just don't answer this. We answer this in TIs. Yeah, it's a subsidy and here's why, but it's not a.
And I think we tried to navigate that by having that they report as,
Yes.
you know, that's in the fact pattern.
Yes.
But are we indirectly acknowledging that, as you point out?
seems like Alan's path is the best path.
Okay.
I.
You may or may not see this in a future version of these questions.
Very good.
Okay. On to continually controversial questions. Let's talk about healthcare. Okay. On to be careful what you ask. Supplemental Medicaid payments. Stakeholders have asked about supplemental Medicaid payments. So another, again, complicated industry. Again, not the simple industry we were thinking about necessarily when we were crafting all of the words around subsidies. The idea that you have a simple service you're providing and it's the rates you're charging are simply, you take all of your costs and you come up with a simple rate based on your costs and that's what you charge. Healthcare doesn't fit that model very well at all, but we'll do our best to apply that in this situation. So we have done, so what's going on with Medicaid? The word is associated with a couple of types of payments that come from the typically states, though there may be some circumstances when it's a different government. So we use the word government in the question. But in the fact pattern, we talk about what we call, I guess, the contractual Medicaid payments. We talk about the idea that these fit what we believe are the standard Medicaid payments are similar to the type of insured health care that is included in the question 4.7 in the 2025 implementation guide update that talks about third-party insured healthcare payments. Those are similar. That type of Medicaid is where an individual meets the requirements of the plan and gets qualified to be covered by the Medicaid provided by the government, and it's either fee for service or sometimes it is the what's it called, the managed care type plan, but it is much more like a health insurance plan, and there are specific rates and there's specific healthcare providers or hospitals that accept those particular patients, and there's a contract with the government similar to like a insurer that will pay the rates based on those particular services or the capitation rates. So that's a particular type of Medicaid service. But what the question was being asked is about supplemental payments that are received. And what's different about the supplemental payments is that the actual patient part gets kind of lopped off on that arrangement. So instead of there being a contract that connects everyone in this arrangement, the supplemental payments are really simply between the governments and the hospitals. The government decides that they want to make supplemental payments to, there's a whole number of varieties of the supplemental payments, but they're simply a payment between the government and variations of healthcare providers that provide services to Medicaid patients. But the fact that the patient themselves is not in that circle of the payment. And that's what we're trying to get across in the question and answer that we have crafted related to that. And we actually, we took out of the question that was actually asked to us was a particular type of supplemental payment. This business of, I guess, a somewhat common one is that they tax particular healthcare providers, you know, a flat tax based on a certain type of service, and then it's parceled out in a different way. We came to the conclusion that the actual way that they receive the amount that they parcel out has nothing to do with the fact that they're simply parceling out monies to particular healthcare organizations. So we're trying to craft in the question and the answer, the contrast these two type of payments, just because they have some similar wording to them or names associated with them. We're trying to focus on the differences between the two in the both the question and the answer. But we need to mention both of them in the question and the answer because the answers are different as to whether they are operating or non-operating. So with that, I will ask question 5. Do you have any comments or observations regarding the proposed question and answer on supplemental Medicaid?
Thanks, Roberta. Board member comments on this one? Jackie?
Happy to hear. I think this is great. I had no problems with the question or the answer on this one, but I do have to say that this whole Q&A caused me to do more research on passenger facility fees, supplemental fees, HUD than I've ever done before. So I agree with your Q&A on this one. Looks good to me.
Thanks, Jackie. Robert?
I agree with this Q&A as well.
Thanks, Robert. Diane?
I agree. We actually do this in Colorado, and it's a whole redistribution. I have audited this, so I know all about this, but I think the question is good. I had to really think about it and go back and look at some of the old stuff that we had done, and the answer I think is good too. And so it's an interesting program, but anyway, it works.
Thanks, Diane. Carolyn?
I agree with this question and answer.
Thanks, Carolyn. Chris? What's good?
No, Chris agrees with this question and answer.
Thanks. Jeff?
Okay, so I'll just mention a couple things. I'm by no means knowledgeable about supplemental payments, maybe in a way that Diane, you are, but here's a couple of questions that just came to mind in the way we characterize the answer. The first has to do with the second sentence, which we say the patient has no contractual relationship for healthcare coverage associated with the supplemental payments. Now, why do we say healthcare coverage associated with the supplemental payments? The supplemental payments have nothing to do with the contractual relationship. Why wouldn't we, could we just say the patient has no contractual relationship for supplemental payments? Is there any coverage, healthcare coverage associated for the patient with supplemental? There is no coverage. And I think we're muddying the water to confuse it with the coverage that is actually done through the primary care. So that was one confusion. And then when we talk about A and B, we say in A, they're not related to. Now, when again, not being knowledgeable about this, so if I understand some of how this is calculated, it's calculated on patient days and all that stuff. So my service that was part of the contractual relationship, because I spent some days in the hospital, separate and apart from that contractual relationship, there is this supplemental payment coming after the fact because it was related to my hospital stay, but not directly because it wasn't part of the reimbursement as part of my stay. It comes when they tally up all these days and figure out how they calculate these. So it's just maybe wordsmithing, but the words related to, maybe it is related to, but there was no services directly provided by virtue of these supplemental. And if you could maybe get clearer to that point, that may also eliminate any, confusion there. So just a couple of thoughts.
Well, Jeff, also that even though you had stays in a particular hospital, you had days of care under Medicaid, then that doesn't mean that hospital is going to get that much in the supplemental because it's just redistributed. They tax everybody, or they charge a fee, as we call it, and put it in a pot. The feds come in and match some of it, and then they redistribute it based on how many days, how much Medicaid providing you have done in each hospital. So if you were an isolated incident in one hospital, your hospital may not get much in supplemental pay.
But to the point though, could you say it was completely unrelated? Could you say it was completely, you would have to, could I say that's not related to? Well,
No, your person counted.
right,
Okay.
you were somehow related in this mix of calculations and reallocations and all that stuff. So maybe if we just say the services weren't directly related to your contractual relationship, that's how we meet A1. Stay away from like it's not related to, because maybe it is related to.
I mean, Jeff, we can work on that word.
But I think, Jeff, to your point, you got to keep reading, right? That clause, it's are not related to the goods or services provided by the hospital as part of the contractual relationship. So it's above and beyond that standard contractual relationship. I don't think you can just take that related clause without looking at, right?
I suggested put with the patient at the end of a relationship, contractual relationship with the patient, which to me makes that a little more clear, but it still doesn't totally help what you're doing. But to Lisa's point, if you keep reading the whole thing and you take it as a whole, you should get beyond your concern, I think. I don't know if the staff has any response to Jeff's first comment. Is that something you're going to work on? I wasn't totally sure I followed it.
I think part of it is you have to read the whole thing together, the phrase contractual relationship for health care coverage, all that together, read it as one word. I think it helps.
Yeah, but that's the first part, the contractual relationship between the patient and the government for healthcare coverage. One clause.
Yeah.
The patient has no contractual relationship for healthcare coverage associated with supplemental.
But you got to read the first part of the sentence, right, where we're trying to contrast it. So we're saying, in contrast to those situations where there is a contractual relationship between the patient and the government for the coverage, in this case, the patient has no contractual relationship for that healthcare coverage associated with these supplemental payments. So you kind of got to look at it. We're contrasting the two pieces here. The first part is when there is a contractual relationship, the second part being when there isn't one.
Yeah, I guess what I'm getting confused about, Lisa, and it may be fine as it is, or it may just be my confusion, right? Because when we say healthcare coverage associated with, I'm thinking for the coverage of the current patient, the current contractual relationship. What is in reality happening is there have been prior contractual relationships that have now been allocated, right? And I'm now in the hospital and I'm unknowingly getting the benefit of those prior contractual relationships by virtue of the supplemental payment. Does anybody understand what I'm saying? So it's just this prior. So I am benefiting, but it's the way I read it when I first read it was it's related to my current stay. And I'm not getting any coverage from my current stay from the supplemental payment. I'm getting it from past payments, but I'm not. Maybe I'll just be quiet.
I'm good with it as is.
Okay.
You might argue the first part is unnecessary. I think it puts it in context a little bit, I guess, but. Anybody else? Everybody else still okay with those after Jeff's comments? I thought this was good Q&A.
Okay, and moving on to the last section is on our non-capital and capital subsidies. We had a question, or we have a question in Implementation Guide 2025 dealing with non-capital subsidies. We have that additional subtotal for operating income and non-capital subsidies. The Statement 103 did not provide guidance on what non-capital subsidies are. So the question in Implementation Guide 2025 tried to provide some additional guidance on that. One of the challenges with that question is, question and answer is the question was somewhat limited and the answer ended up being more of a broader principle than the question. And that's what was troubling, and we found it could be misunderstood and misinterpreted. And so we found it seemed like the best thing to do with that question was to recraft the answer to answer it more specifically to what we were trying to answer in that question. In the question, we were talking about this idea of receiving resources. It was whether your use of the resources or whether the provider of the resources, whether they provided limitations on how those resources were used, which side of that had an influence on whether it was capital or non-capital. And so we recrafted the answer to answer that specific aspect of it rather than trying to provide broad conceptual guidance on what is a capital subsidy and a non-capital subsidy, rather than making it very broad, because we ended up creating a broad principle that actually hadn't contemplated everything we should be contemplating about what is capital and non-capital subsidy. So you'll see that we have redrafted the question a little bit, and that the answer primarily to limit the answer to not be quite as broad as it was originally. And then we proposed a new question for some questions we had gotten, which had arisen. It's kind of like, well, it seems like the answer to this is very limiting as what can be considered a capital subsidy. So we have crafted an additional question to clarify that particular circumstance that we were asked about. So we have on page 10, we have marked up the original question 4.5 from Implementation Guide 2025 to make that a little narrower, to make it clear that is the limitations of the provider of resources that will determine whether the item is capital or non-capital. And then there is the new proposed question having to do with limitation related to debt service for capital related debt. So with that answer, I'll ask question 6. Do you have any comments or observations regarding the proposed amendment to the existing question and answer, or the new question and answer that I just mentioned?
Thanks, Roberta. I would say overall, I'm fine with the new one. I'm fine with the new one. And I understand the reason we shrunk or amended the prior question. But I feel like there's a couple of things that we crossed out that I would rather leave in. And it seems like we should be able to do that without missing the shrinking of the broad, without affecting the fact that we are still unbroadening the question. That's not the right phrase, but that was the one that came to mind. The two parts that I thought were good guidance, and I think if I'm remembering correctly, both of these were added when we put this Q&A in the first time based on comments we got from stakeholders. The first one being the parenthetical in the answer that describes what a capital subsidy is as a parenthetical, it says that is all subsidies other than non-capital subsidies. When we first proposed this Q&A and we talked about capital subsidies, I think we had stakeholders say, what are capital subsidies? You don't use that phrase in statement 103. So we added that parenthetical. I would prefer that parenthetical to stay because we're still, even in this answer, later in the answer as it's left, we still have the word capital subsidy. I'd prefer to keep that in. And then the last sentence or some version of the last sentence in the last parenthetical of what you do with non-capital subsidies, meaning they should be reported as other non-operating revenues and expenses. I get that that's maybe, that is maybe a broader thing, but I think stakeholders were interested in knowing. And is there some way to keep that notion in these Q&As? I think it would be helpful to retain that as guidance. Those were my reactions to it. But in principle, I'm fine limiting it more, but would like to keep those two parts of the guidance in there.
So Joel,
Yes, please.
I think your first point about moving that parenthetical that we crossed off to that sentence where we do refer to the capital subsidy, I think team agrees on that's a good addition to bring back into the answer.
All right.
In regards to keeping that last sentence about how they're reported versus how they're classified, our concern there, right, is that that's much broader than what the question is asking. The question is asking how they're classified, which would be as a capital subsidy. So the question doesn't ask about reporting them, right, whether they'd be reporting them as non-operating. So that would be our concern with keeping that one. The way around that might be to add a secondary question to this that specifically asks how that would then be reported. If you feel like that's important, then I think that might be a better way to address it, where we add that second question.
I am fine with that. I personally feel like it is important because I remember stakeholders asking us what to do then, and that's why we added that sentence in. But if other board members don't feel strongly, then I get that it is broader than this specific question. So if answering it is breaking it out, that's fine with me too.
Because we've also, in the new section, right, we have a related proposed new question that, it's the question, the new question. And we don't address the operating or non-operating in that. So if we had a second, another new question, we could address the operating, non-operating sort of for both of those pieces.
It wouldn't be related specifically to that. It's like
Right.
just apply, period.
Yes.
Okay, then I'm good with that. That makes sense to me. Other board member reactions? So you think we could add that as a other question, separate new question?
Yeah, we're not going to promise, but we'll take a look.
Okay. Thank you for taking a look. Jeff just asked, are we getting that as a new question? So Jeff cared too. Board member thoughts on the amendment and the new Q&A, and thoughts on my responses if you disagree with my suggestion. Robert, then Diane.
I was fine with the new question. I had the same question about deleting that last sentence in the amendment. But then I have another question. Is a subsidy other than a non-capital subsidy a capital subsidy? Couldn't we, or is there yet another type of subsidy that's neither a capital?
That's
nor
it.
not?
That's it. It's binary.
Okay, right. So could it be clearer if we do a new question to address, keeping that proposed deletion, to say, how should a capital subsidy be reported? because then it's just direct, then to make it very clear.
Yep.
Yeah. Okay.
Yep. We got it. You were on the-
Thanks, Robert. Diane.
I was fine with the original of everything, but I'm good with all these additions, so I'm okay.
Thanks, Diane. Carolyn.
Similar to Diane, I was fine with the original new question and the proposed question with the strike-throughs, but I also like the suggestion that Joel made as far as adding another new question to address and I highlighted the parts that you wanted to be covered. So I agree with the original. I agree with the staff recommendation with Joe's amendments.
Thanks, Carolyn. Jeff.
I think I'm okay with all that's been talked about. I just want to make sure of something, given that we're focusing on precision in these questions, and I just wanted to make sure. So in the question, we use the term acquisition of capital assets twice, and in the answer, we say capital purposes twice. Do we mean acquisition of capital assets? Do we want to have them be the same? Are we okay with them being different in the question versus the answer? I'm seeing Roberta nod yes. I just want to make sure for precision purposes, we're not trying to go beyond what we're setting up in the question by how we phrase the answer.
Well, I think we're saying an acquisition of capital assets is a capital purpose.
Okay.
And in the answer, we say in this circumstance. So I think that gets us back there.
Okay.
So you were good then? Okay. And Chris?
Chris was good with the edits and Chris was good with the new question.
Okay, very good. Jackie, sorry.
Yeah,
I
you-
knew, I
expected
kept
me
looking
to be
back at you
last,
because
right?
I knew, and then I'm not used to you going last.
I actually wanted to hear what the board had to say about the new question and answer. So I support the revised wording. However, I'm fine with the recommendations that Joel has made too. I kind of like the idea of the second question covering both of the ideas that you're talking about. And I'm fine with the proposed new question too.
Thank you, Jackie. All right. That's what we got
So
so far.
We just need your non-objection to us bringing you a pre-ballot of the implementation guide at the next meeting. So if you're okay with that.
Yeah, let's
Jeff?
ask.
I do not object.
Thank you. Carolyn?
I do not object.
Oh, him not being here is messing me up too, with Chris not being here. Diane?
I do not object.
Thank you. Jackie?
I do not object.
Robert?
I do not object.
Mr. Chair?
I do not object.
And Chris did not object either.
Very good.
great. So that means at the December meeting, we'll bring pre-ballot draft before you. And the only other thing I wanted to mention, because it was mentioned in the GASAC meeting, was the AICPA potentially having some issues that they wanted to bring to our attention. So I did have a conversation with Michelle after the meeting, and she's going to work really hard to get their people to send them our way. Hopefully, there's a chance that their issues are already addressed here. The staff will take a look at those. If we do have a circumstance where we want to bring a new Q&A before you, then we will also do that at the December meeting as a separate paper aside from the pre-ballot draft.
Thank you for working those in.
You got it.
So we appreciate that. I know we're crunching it in, but
Yes.
we're trying to be timely in our guidance.
And
but
listen to
also
stakeholders.
responsive, right?
Right.
So I appreciate you doing that, and I appreciate Michelle and the AICPA getting us that information quickly, which we asked for. So thank you, team. Look forward to the next meeting and what you bring back. All right, we have one more topic for today, but I think we could take a break and come back and talk about going concern, uncertainty, and severe financial stress at 4:20. So 15-minute break or so. See everybody then. All right, welcome back. Hope everyone had a good break. We are on our last topic of the day, which is our going concern uncertainty, severe financial stress project, probable dissolution thrown in there too. Deborah, I will turn it to you to walk us through what you have.
Thank you. Good afternoon, everyone. It's been a little while since this team has been in front of the board with discussion questions for deliberation, and that is because we issued the preliminary views back in March, severe financial stress and probable dissolution disclosures. We had a good response to that preliminary views. We received 38 comment letters, which was a mix of traditional comment letters and people filling out the electronic feedback form on the website. So that continues to be a good process for us to solicit feedback from stakeholders. After the comment period ended, we held the series of 3 public forums. We had a total of 25 participants in those 3 forums, a mix of preparers, auditors, and users. Of course, the board was there for all of those forums, and we had some really good discussions and got some additional feedback through that process. So here we are starting the redeliberation process. We have for you just 2 topics, both related to the scope of the project. We did discuss these issues with our project task force, and their feedback was incorporated into the paper before we finalized it. So the first topic that we are looking at today is at a very high level, having separate disclosure requirements for poor financial condition and continued existence. So the preliminary views propose that there would be 2 independent sets of disclosure requirements. In that preliminary views, they were called severe financial stress and probable dissolution. For the purpose of our discussion today, we're using broader terms so as not to be perhaps focused just on what those terms meant as they were proposed in the preliminary views. We're talking at a very high level, broad concept, and we'll get to what those are called and what the details of those disclosure requirements would be later on. So stakeholders generally agreed that there should be different disclosure requirements for the 2 circumstances, recognizing that governments can be in a very poor financial condition, but not at risk of ceasing to exist, and governments can and do cease to exist even if they're in a good financial condition. There might be other factors leading to that. There were some stakeholders, though, that disagreed and want the disclosures related to continued existence only if it's related to a poor financial condition. We believe that the user outreach that has been done in the course of this project, both in the pre-agenda stage and leading up to the preliminary views, indicates that users do want information about governments that are in both of these circumstances, even if they're one and not the other. And that includes uncertainty about continued existence, even if it's unrelated to financial condition. The stakeholders who wanted a narrower scope may be looking at this project as being just about going concern uncertainty, rather than perhaps being broader of setting disclosure requirements that might go beyond going concern. Now, we will get to going concern later. We're not going to discuss that today. But for now, we're looking at, do we want to have disclosure requirements for both a government in poor financial condition and a government facing uncertainty about its continued existence? The project staff believes that there's enough evidence to justify pursuing both sets of disclosure requirements, even if those end up being broader than anything we might define as going concern. So discussion question number 1 is, should the scope of the project continue to include separate disclosure requirements for poor financial condition in uncertainty about continued existence, and we recommend that it should.
Thanks, Deborah. Board member responses to question 1. Jackie.
I continue to believe that we need separate disclosures for these, whatever we call them, whether it's poor financial condition, uncertainty about continued existence, or something else. The majority of commenters and even the forum participants agreed that these are different conditions in government. And for that reason, I think that because they are different conditions, we need to have disclosures related to each of them.
Thanks, Jackie. Alan?
I'm going to read it. It's just because
Chris, okay.
I'm going to read
Chris.
Chris just because in this case, it's not just one, it's not just I agree. So I agree with the staff recommendation. This is Chris's words, obviously. Governments versus for-profit entities are inherently different in their purpose, authority, legal standing, and often in their funding structure. Given the differences that exist between the two entity types and the underlying causes for dissolution and financial uncertainties related to each, I support separate disclosure requirements.
Thanks, Chris. Carolyn?
I agree with staff recommendation. For those that disagree with the bifurcation, they seem to lean towards not disclosing mergers or acquisitions, but enough stakeholders agree with the benefit of separating the two concepts, so I agree moving forward with 2.
Thanks, Carolyn. Robert?
I agree with the staff recommendation as well, and echoing Jackie's comments on the feedback that we received from stakeholders, and which was amplified by the commentary and that we received from GASB yesterday, that was clearly indicated that they would agree that we should have separate disclosure requirements for both issues.
Thanks, Robert. Diane or Jeff? Diane?
I agree with staff recommendation. I think users have consistently indicated their desire for this information. And I think by splitting these disclosures, more information can be provided that does not necessarily overlap as in the existing standards. So I think this is really good, and there's going to be more information about the government given to users through this process.
Thanks, Diane. Jeff?
So yeah, I agree with much that's been said. I agree that I think much of what we heard was not so much about the splitting of the requirements or the disclosures, but what this notion of going concern is going to be, right? And I got a little thrown, Deborah, when you wrote and you said, you know, the scope of the project's not limited to going concern uncertainties. And I read that to mean, well, it depends on what this board defines going concern to be, right? Like, so if I define it in a certain way, I will believe that, of course, everything that we're going to have is going to be going concern. Now, that may not necessarily be what current people believe or what their interpretation of going concern is, but that's ultimately what this board is going to have to figure out. So, and I agree with Carolyn that I think a lot of the concern has to do with mergers and acquisitions and the like, and all those discussions are to come. So, but for the question at hand, I would agree that to have both requirements, both sets of disclosures, have them separate is appropriate and should continue.
Thanks, Jeff. I agree with the staff recommendation as well. I think it's really the whole purpose we're in this project is that the existing going concern guidance that kind of pairs these two concepts doesn't work well in the government environment. It was written for the private sector largely, and that's why we're here. It's inconsistently applied. So I think we have to separate them. I think they're both important. We've heard that, like my other fellow board members have said. I think we heard from commenters. We definitely heard it at GASAC yesterday, even some that might think differently about what going concern is and how going concern applies to these two concepts. They all seem to agree, yeah, these are two separate concepts in the government environment. We just have to figure out how to mix and match them and deal with them as it relates to what you may call going concern, or whether we even use the term going concern. But certainly these two broad things are separate, sometimes related, sometimes not, issues that are important in government. And I think we should continue to think about them separately and move them forward. And I look forward to the whenever the discussion is on going concern, certainly will be an interesting one, at least based on the GASAC conversation from yesterday. So.
All right, so that takes us to our second and final topic for today, which is consideration of a liquidation basis of accounting. So the scope of the project, when it was added to the agenda, was limited to just disclosures, which would exclude considering a liquidation basis of accounting, because that would get into recognition and measurement issues. Some stakeholders requested that we do expand the scope of this project to consider providing guidance about a liquidation basis. Now, as a side note, our guidance currently has a definition of what a basis of accounting is, and says there are 3 of them: cash accrual and modified accrual. And that guidance goes all the way back to NCGA Statement 1. So it's been around a while. If we were to consider something, we might need to use a different term than basis of accounting, but just for the purpose of this discussion, we're going to use that, knowing that it may not be what we would actually call it if we were to do one. But alternative 1 is to not expand the scope of this project, keep it only limited to disclosure requirements. That would mean that because there is currently no authoritative guidance that provides alternative recognition or measurement when a government is liquidating, other than perhaps a little bit in Statement 58, it would just be implied and assumed that there is no liquidation basis. Alternative 2 is to expand the scope of this project into recognition and measurement issues to consider a liquidation basis. Now, that might mean we create a liquidation basis, or we consider it and say, no, we don't want to do that. But either way would involve expanding the scope of this project. The project staff does not believe that there is a sufficient need for guidance in this area to justify expanding the scope of this project beyond disclosures, and our task force members agreed with that. I think most of our GASAC members agreed with that also. So question 2 is, should the scope of this project be expanded to consider providing guidance on the liquidation basis of accounting? And the project staff recommends not expanding the scope.
Thanks, Deborah. Board member responses to question 2. Chris? Diane?
I'll go after her.
Okay. I agree with the staff recommendation. I think the basis in Statement 56 indicated that the board chose not to address the liquidation basis of accounting. I thought it was interesting too at the GASAC discussion that one of the GASAC members mentioned that they had only seen this one time in all of their work. So this, I just see very little value in expanding the scope for this. So I agree with staff.
Thanks, Diane. Chris's comments?
No, Chris would agree with the staff recommendation not to expand the scope of the current project to include a liquidation basis of accounting. From his standpoint, there's a potential can of worms that opens up, and there's a lot we don't know. So rather keep the scope as it is and not expand the scope.
All right. Thanks to Chris. Carolyn?
I agree with the staff recommendation. I think I recall a dozen TIs since 2003, which leans toward this not being an issue faced frequently by governments.
Thanks, Carolyn. Jackie?
I also agreed with the staff recommendation not to expand the scope to include the liquidation value of accounting. Don't think we should expand it beyond what we're doing and trying to look at measurement attributes and things like that. The other thing is, I'm not sure that I think that liquidation value, and this was brought up by one of the GASAC members, even applies in most situations where the legal entity fails to continue to exist, because many of those assets get transferred or something else. So I'm not even sure the liquidation value would be the appropriate one if we were to include something.
Thanks, Jackie. Robert?
Concur with the staff recommendation, and I think I don't know if it was the same GASAC member, but basically had comments about even if liquidation basis, it's winding down, it's at the very end, and the prevalence of that in the government environment is so infrequent that going down this road and expanding the scope of the project, I think is not worth it.
Thanks, Robert. Jeff?
Yeah, I I hear what my fellow board members are saying. I guess the only thing I struggle with is when we say in the sentence here, authoritative guidance would continue to remain silent, although that silence implies there is no different recognition and measurement. So I think what we're all sort of saying is we're just going to continue to remain silent, and silence leads to an outcome. And so I would be more willing to say, if I understand what I think other board members to be accepting of that outcome, then I could see a world where we just say, expand the scope, but just say, there is no liquidation basis of accounting in governments. One sentence, you're clear, the problem is solved forever. You're not leaving this ambiguity out there. So part of me says, wouldn't that be a tidy conclusion, right? If I don't get that conclusion, then at least I want to say, hopefully something in the basis that sort of fills the void of the silence, right? Where it's like, okay, we thought about this and here's why and I didn't find statement 56 to be particularly fulfilling in that. Like, we chose not to deal with it. Well, why didn't you choose not to deal? What were the issues? I don't know. So to the extent we can say something that this is why we just don't think it's worth it. Maybe it's a prevalence argument, maybe, all these things we've talked about. I'd rather say something that at least, we've chosen to explain ourselves rather than, keep a void of silence.
Thanks, Jeff. I agree with the staff recommendation for many of the reasons my fellow board members have said. I don't think it's very pervasive. It doesn't happen. We've noted many times governments often don't cease to exist. This was pointed out, even when they do, often other governments take over the assets, et cetera. Pure liquidations just don't happen that often. And for those that might, we do have, as Deborah pointed out, Statement 58, if your government can declare bankruptcy, then you declare bankruptcy under Chapter 9. We tell you in 58 what to do. And a part of me doesn't want to say the liquidation doesn't apply, because 58 it doesn't talk about liquidation specifically, but the way it talks about how to measure assets if you're not going to continue as a going concern veers that way, right? In a way. And so I would hate to say it just doesn't exist when 58 has aspects of it in it. And even yesterday, there was some GASAC member that talked about in our situation, the state kind of would drive what happens, which almost sounds like the bankruptcy court. And there might be situations where you can analogize to 58. And so I don't know that we're totally bereft of things you can think about, at least in our silence, but certainly to consider them all when it's just so not prevalent doesn't make sense for us to spend time on and expand the scope of this project because of that. That wraps us up.
Nice, easy start to deliberations. The next conversation will be really fun because we're planning to bring you the question of what do we do about the term going concern, which we got a little preview with GASAC yesterday. And so it It's going to be fun.
We look forward to that conversation when it's ready. I did want to commend you, Deborah, and the team for the visuals you provided to the GASAC, all the circles and everything of alternatives and things to consider. I think they really hit home and were very well done. And I think the GASAC appreciated them. So kudos to that. I suspect we might see those or versions of those again in the future, but very well done. So we look forward to that conversation and paper when it is ready in time. All right, that's all we have for the board meeting for today. Action-packed, busy day. We will start again with our 3 topics for tomorrow at 8 a.m. tomorrow morning. Early start, or at least going to use the morning start, where we will talk about revenue and expense recognition, the voluntary digital financial reporting project, and infrastructure. Knocking out the projects. So see everybody at 8 a.m. tomorrow. I would ask Greta if we're in the same room, but Greta's not in the room. So same room. All right, well, same room. See everybody at 8 a.m. Hope you have a good night.